All please rise. Welcome to the Chief Judge's 2025 hearing on civil legal services. May I present the President of the New York State Bar Association, Kathleen Sweet. Presiding Justice of the Appellate Division, First Department, the Honorable Diane Renwick. Presiding Justice of the Appellate Division, Second Department, the Honorable Hector LaSalle. Presiding Justice of the Appellate Division, Third Department, the Honorable Elizabeth Gary. Presiding Justice of the Appellate Division, Fourth Department, the Honorable Gerald Whalen. Chief Administrative Judge of the New York State Unified Court System, the Honorable Joseph Zayas. And the Chief Judge of the State of New York, the Honorable Rowan Wilson. The hearing will now begin. Please be seated.
Good afternoon, everyone, and welcome to the hearing on civil legal services, and thank you for coming. I'm extraordinarily grateful to be joined by my colleagues, the presiding justices of the Appellate Division, the Honorable Diane Renwick, the Honorable Hector LaSalle, the Honorable Elizabeth Gary, and the Honorable Jerry Whalen. Also delighted to be joined by my partner in the administration of the courts of the State of New York, Chief Administrative Judge Joseph Zayas. And also want to extend special thanks to Kathleen Sweet, the President of the New York State Bar Association, for co-hosting and joining us in this event. Special thanks also to the Honorable Christina Reba, Honorable Seth Marnin, and Janet Sable, the co-chairs of the Permanent Commission on Access to Justice, who have stepped in to very ably fill the shoes of Helene Barnett, who chaired this commission from its inception for many, many years, and we do miss her. As the federal government continues to cut funding for essential programs and services, many of us draw some measure of comfort because we live in New York. New York State's governmental leaders have shared a demonstrated commitment to working towards a future in which all New Yorkers have access to opportunities and resources required to live peaceful, productive, and prosperous lives. As a result, it may feel as if we have some measure of protection from the federal retrenchment happening all around us. Indeed, in the most recent budget cycle, state funding for civil legal services in New York reached an all-time high. For the 2026 budget, we identified the Judiciary Civil Legal Services Program as one of the Unified Court System's top priorities. We sought and we received $150 million in funding for the coming fiscal year, a very significant increase of $45.5 million over what we received the prior year. We also expanded the Alternative Dispute Resolution Program by $3 million to strengthen mediation and arbitration services, and we enhanced the Attorney for the Child funding by $6.5 million, reflecting a 35% increase in funding since fiscal year 2023. Despite those significant commitments by our partners in the executive and legislative branches, despite New York's status as a nationwide leader in funding civil legal representation, everyone here knows that there is a tremendous amount of work still to do in both the state and the nation to close the gap in access to civil justice. 2 years ago, New York's Permanent Commission on Access to Justice concluded a years-long study and published a conservative estimate of what it would take to provide civil representation to persons at or below twice the U.S. poverty line for matters affecting the essentials of life. That is, matters related to housing, family issues, access to health care and education, consumer debt, and disability benefits. The Commission estimated that nearly an additional annual $1 billion would be required in New York, a staggering number that was calculated before the current uncertainties around federal funding arose. Putting aside the sheer enormity of that shortfall, two other points deserve our attention, one cautionary and one exhortatory. First, research in the relatively new field of inflation inequality shows that inflation disproportionately damages less wealthy families and individuals. For example, research conducted by the Center on Poverty and Social Policy at Columbia University concludes that when inflation inequality is accounted for, millions more people would be classified as living in poverty. So the size of the need is substantially greater than estimated by uses of conventional measures. Second, remembering that civil representation helps avoid evictions, avoid job loss, avoid loss of benefits, avoid the unnecessary breakup of families, and avoid crushing consumer debt bills, research consistently shows that the provision of civil counsel to those who cannot afford it avoids social costs that far exceed the costs of counsel. State-specific studies by the Legal Services Corporation show that a dollar spent on indigent legal civil representation returns between $5 and $10 in avoided social costs, which does not take into account the non-monetary costs of psychological and emotional damage when, for example, a family loses its home. Over the next several years, it is clear that we must continue to increase state funding for civil legal services. We must identify creative ways to increase the number of rural practitioners. We must increase salaries at our institutional providers so they can attract and retain capable lawyers who handle manageable workloads. We must partner with the private bar to redouble our pro bono efforts, and we must increase the guidance, tools, and resources available to those who still find themselves in court without counsel. We need to consider alternative ways to provide some assistance, especially in areas facing shortages of lawyers, because some legal assistance, whether from a non-lawyer or non-human, is better than none at all. Having a fair day in court must not depend on where you live or how much money you make. It is a basic right to which every New Yorker is entitled. For the rule of law to survive, people must believe in it. It is very hard to believe in a system that perennially stacks the deck in favor of the wealthy while leaving the less fortunate to fend for themselves, unaided by counsel. In a democracy which fundamentally depends on the public's belief in the rule of law, in due process, in equality of treatment under law, in liberty and justice for all, we're inextricably linked. The injury to the justice system caused by systemic inequality of treatment damages us all. It damages the very fabric of the democracy that we rely on to bind us together. So today, as we listen to our fellow New Yorkers' challenges and opportunities, I encourage all of us to hear their testimony, not just as his challenge or her challenge or their challenge, but our challenge. As Dr. King wrote from his Birmingham jail cell, I am cognizant of the interrelatedness of all communities and states. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Wherever affects one directly, affects all indirectly. Just as we are all interpersonally connected, so too is New York bound to our sister states. That is the starting and ending point of and premise of our constitutional democracy. On that point, I am pleased to introduce our first speaker, the Honorable Nathan L. Hecht, the former Chief Justice of the Supreme Court of Texas.
Thank you, Chief Judge Wilson, and members of the distinguished panel. As the Chief says, I'm Nathan Hecht, formerly Supreme Court Chief Justice of the Supreme Court of Texas, now a partner at the Jackson Walker Law Firm in Austin, and a distinguished judicial fellow at the NYU School of Law. And I'm joined by my wife, Judge Priscilla Richmond of the United States Court of Appeals for the Fifth Circuit. I'm very honored to be here, of course, and humbled to appear before you in this courtroom over which my very good friend and former colleague on the National Conference of Chief Justices, Jonathan Lippman, once presided. Jonathan and I were each president of the Chiefs at various points, and there's a lot of collaboration among the Chiefs and some competition now and then. So Jonathan and I, knowing New Yorkers and Texans' view of each other, he and I had a very beneficial joint pact. If either one of us had a good idea, the other could steal it without attribution, lest it be received DOA when we got back home. So it's in that spirit, Chief Judge Wilson, that I come. Without intending to oversimplify things, three crises have converged on the American justice system. One is access to justice for the poor. A second is loss of public trust and confidence in the judiciary. And a third is a threat to judicial independence. None of these is new. All are historically severe just now, and their convergence challenges the integrity of the rule of law and the promise of equal justice for all. I offer that in addition to advocating for additional funding for basic civil legal services, judges' personal engagement in improving court administration, making it run better, is a constructive response yielding benefits to all three and strengthening the public's view of the judiciary. So, crisis number one, access to justice for the poor. You don't need to hear about this. There's lots of statistics. The one that strikes me is a recent counting of cases in the state courts of the United States, some 30,000 judges. The estimate is about 68 million cases were decided in 2023. About 20 million of those were civil. The count was that in 75% of the cases pending in state civil courts across the country, one party or both is not represented by counsel. That is a blow to the parties themselves. When you're unrepresented, you have a better chance of losing. When it impedes courts because they have to deal with pro se dockets, and it damages society, and the makes equal justice an empty promise. What judge among us, usually serving at some personal sacrifice, wants to preside over a system in which justice is available to only those who can afford it? For the judiciary, the government, and the people we serve, we absolutely must do all we can to close the justice gap. I call it the justice chasm. It is so wide and unyielding. We can improve funding, as New York is constantly doing, and I agree with the chief. New York has been a real leader in this for the rest of the states, including Texas. Another thing we can do is to try to make sure that access to justice is completely nonpartisan, so that it is supported as a good government issue rather than drawn into the political divisions that now divide us. The first President Trump administration budget had zero in it for Legal Services Corporation. The present budget recommends that LSC be eliminated. In the first administration, the Congress continued to raise funding for Legal Services Corporation. In this second one, although they have not acted on a budget issue yet, the Senate raised the budget $5 million, which is not very much, about 1%. But the House had cut it to about 60%, but they've not acted on that yet, so we still don't know what's going to happen. And with the budget outstanding, just that funding alone, just the Legal Services Corporation funding, is in question, as is access to justice for the people who are clients of legal aid throughout the United States. A simple legal matter for the poor is like Mount Everest to climb, or most likely to fall on. Strong state funding is important for two reasons: the money, but also because it represents the constituent support for this issue that sometimes has a lawyer flair to it, kind of sounds like a lawyer issue. My friends in Congress tell me that you don't get a better response sometimes than you do because it's only lawyers care about this. You show me a used car salesman who cares about access to justice, and I'll be more engaged. But state funding helps generate that because it comes from the constituents back home that this is something that we all need to be doing. And as you approach the 150th anniversary of the bar next year, it's something that the New York Bar can really help lead on. Crisis 2, a profound historic decline in public trust and confidence. National Center for State Courts polling shows that do state courts provide equal justice to all? 47% said so in 2024, 47%, up from 43% in 2022 and down from 62% just 10 years ago in 2014. Do you have confidence in state courts? 63% said yes in 2024. 61, that's over 61% 2 years earlier, but down from 76% in 2014. And our courts political? 59% thought so in 2024. In 2014, 10 years ago, only 48% thought. So that's a sign of what the public is hearing about the justice system and how it is affecting their appreciation of it and of the rule of law. And then the third one is, third crisis is attacks on the judicial independence. Thomas Jefferson was not for judicial independence. I guess he would be cheering now if he were around. I doubt it. He might look around and see the mistake of his thinking, and Hamilton was right after all. But it's not new. FDR tried to pack the U.S. Supreme Court. President Obama criticized Citizens United to the justices who were sitting there at the State of the Union while he was talking. President Trump, my goodness, has hugely escalated attacks on the judiciary throughout the country, pressures from all sides for judges to take sides, and it really seems to be at a much higher pitch than any time in the last 43 years when I was a judge. So what can we do to help? We can't change our decisions. We follow the rule of law. We don't have constituents. Our constituents is the cause of justice. And what we can do is that when judges and courts individually, and this is clearly within ethical boundaries, engage, invest, are hands-on, shoulder efforts to improve the administration of justice, to make it run better, in turn helping bridge the justice chasm, because that makes it easier for not only for people to represent themselves, which is a terrible thing to have to do, but even for legal aid providers to provide that representation more efficiently and inexpensively. The public perception of the judiciary is improved and judicial independence is justified. I'll just give you 4 quick examples. There's a zillion of them. Particularly these days, I can tell you from my experience with the Conference of Chiefs, and the Chief Judge is there as well, the courts around the country are talking about this and looking for ways to make it better. How? Letting non-lawyers provide some basic legal services. We call them paraprofessionals in Texas. We're still waiting for it to get approved, but it's been approved, I think, in a dozen states so far, started in Arizona and Utah. It's a very viable way to get a little, it doesn't solve the problem, but to get a little better representation to the people who need it. Second way, alternate methods of licensure and legal education. Again, the states are all talking about this. The Conference of Chief Justices just put out a report called CLEAR, C-L-E-A-R, that's the acronym for their committee. After exhaustive interviews around the country, these are ways that we might incentivize lawyers to provide legal services, to go to rural areas that don't have lawyers, to make it better for lawyers to provide these kinds of services. 3, differentiated dockets. The federal courts have had those for a long time. Bankruptcy, patent, tax. State courts have had it for a long time. Family, housing, debt collection. I often say that if courts were a business, we'd be bankrupt because we don't care about our customers. These are ways, these structured dockets are ways to make it easier for people to go to court if they have to. If you don't have to drive downtown, get daycare, take off work, find parking, and sit around a courthouse listening to legalese all day long for a 10-minute hearing on something that's critically important to you, guess what? The public response is unsurprisingly positive. So that's another way of changing the way we do business to make it better for our public. And 4, sorry to mention this, but the dread AI is out there, and it's not going away. And lawyers don't like change, but we're finally trying to look for ways where we can use its tools to make the administration of justice and the practice of law less expensive and more efficient. I know from the Permanent Commission's annual report that New York is a leader in this. Judge Lippman used to tell me I had to read it, and I did because he told me to, and now I steal it from it every year without attribution, except here. And today, I come to just stress the importance of judges' personal and the judiciary's institutional investment in these advances and the promise improvements in the administration of the courts. When I started as a trial judge 43 years ago, I thought you went through the stack of cases on your desk and you went home. And the only thing I had to do with court administration was begging the county for money whenever we needed it, which was all the time. Now, courts are inescapably drawn into administration of the court system because the public that we serve desperately needs it, and the rule of law to which we are devoted commands it. There's no more deserving cause. And I'll just add one more thing. When we do this, we need somebody to brag for us, Judge Zayas, and so we're counting on you and your folks to say, this is what the courts are doing, and this is how it's making your life as New Yorkers, as Texans, as Americans better. Again, it's an honor to be here, and I'm happy to answer any questions.
Thank you. Let me start out with a question for you. So the sort of public opinion of the state courts data that you referred to, and I don't want to put you in a difficult position with Judge Richman, but you omitted the public view of the federal data, and it trends much worse than the state data. And the states are ticking up a little bit and the federal is still. And so my worry is the following, is that when you read the papers or however you get your news information, it's almost always about federal courts. There's really very little in the public mind about the state courts. I'm not even sure why they think the state courts are better than the federal courts, because I'm not sure what they know about the state courts. But if there are ideas we can steal from you about how to differentiate the state court from the federal courts, I'm all ears.
My thought is that, incidentally, the fact that state courts are more highly regarded than federal courts does not help me at home, but it is a fact. And I think the problem is that the only thing people know about the federal courts, because there's a limited number of them, they have limited dockets. Mostly what you know about the federal courts is what you read in the press. Millions more people, millions and millions more people are going into the state courts every year. And so their experience is more having been there. And my idea, and this is what I've come up with so far, is that if you can make it, if you can show that you're making it work better, the car runs better, you're getting more accommodation for your need. Just one quick example, the misdemeanor courts in Houston about last year sometime went out and did a expungement kind of fair on a parking lot on the weekend. And the Houston Chronicle wrote it up like, oh my gosh, they've saved, this is saving the justice system. Well, it's a little bitty thing, but it's something that you could do that people react to and say, okay, if they have a better experience in the divorce courts and misdemeanor courts, then it's better.
Thank you. Questions? Thank you, Chief Justice.
Thank you very much.
Our next speaker is Christine Fecco, the Executive Director of the Iola Fund.
Chief Judge Wilson, Chief Administrative Judge Zayas, Presiding Justices Renwick, LaSalle, Gary Whalen, and New York State Bar President Sweet. Good afternoon. My name is Christine Fecco, and I'm the Executive Director of the New York State Iola Fund and a member of the Permanent Commission on Access to Justice. The Iola Fund is a public fiduciary fund dedicated to supporting civil legal aid organizations across New York, which we do primarily through general operating grants. Alongside our partners at the Office of Court Administration, in fiscal year 25, the Iola and JCLS grant programs together provided nearly $200 million in funding to over 90 nonprofit legal service providers. The legal services sector employs over 5,700 people and coordinates over 40,000 pro bono volunteers. In fiscal '25 alone, Iola-funded programs served over 1.1 million New Yorkers and closed over 330,000 cases. I've been asked to present about the impact of federal funding cuts and program restrictions on the legal services community and the people served by these organizations. In response to this request, I offer a clear message. Recent and anticipated additional federal funding cuts and restrictions pose a serious threat to the civil legal services safety net in New York State. This moment requires urgency. The erosion of federal support for civil legal services threatens not only our sector, it threatens the bedrock principle of equal justice for all. In their fiscal year 2025 reports to Iola, our grantees disclosed receiving $137 million in federal funding. This represents 14% of all legal services funding in the state. And this funding supports more than 50 legal aid organizations. These funds are critical. They sustain programs that help people secure the essentials of life. As Judge Wilson mentioned earlier, family safety, housing, education, disability, employment rights, immigration, and public benefits. And they are all now in jeopardy. Excuse me. As Judge Hecht mentioned, the Legal Services Corporation, which is the largest source of federal funding, provides nearly $34 million in fiscal '25 and has been zeroed out in the executive budget. New York's legal services organizations here in New York collectively assisted over 450,000 New Yorkers with their legal problems in fiscal '25. So any LSC cut would be devastating. LSC itself, and while we don't know what that cut will be, LSC itself has advised its grantees to expect a minimum of 20%. Excuse me. This would be a loss of $6.8 million. LSC, however, is but one piece of the federal funding puzzle. Funding from 3 federal agencies, DOJ, HHS, and HUD, account for $81.7 million, or nearly 60% of the federal money supporting civil legal services in New York. Grant funding from 5 additional agencies, the IRS, the Social Security Administration, the Departments of Education, Treasury, and Veterans Affairs, account for another $13.5 million. The future of all of this funding is entirely unclear, of course, and I can't, look into a crystal ball. But news, the news is also very complicated by all of the competing court cases, injunctions, appeals, et cetera. But when we look at the data, our estimate is that we see up to $80 million in funding, federal funding, to New York civil legal services as at significant risk. The timing, of course, is also unclear. Some cuts have already happened, some are pending in court, others are likely to come in the fiscal '26 budget, others may be felt in later years. But I want to just walk you through how I get to the $80 million. When we look, we can look first at the federal agencies most likely to cut or eliminate funding. In addition to the LSC cuts, I see the elimination of funding from DOJ, HHS, as well as Treasury, Education, the Social Security Administration, and the IRS. And let me just briefly touch on why I've singled these funding sources out. The Department of Justice has frozen $3.8 billion in grants and canceled $811 million in previously awarded grants. This has primarily affected victims of domestic violence and other victims of crime. DOJ has also frozen $34 million in its legal orientation program affecting immigration legal services. HHS grants largely support immigration, refugee resettlement, and legal services to people living with HIV or AIDS. The current federal administration has already deprioritized these issues and drastically reduced their funding. including the termination of $370 million in funding for legal services for unaccompanied minors. The Social Security Administration supports legal assistance to people with disabilities and the elderly. Likewise, the Department of Treasury provides pass-through funding to New York State that supports a wide array of grants that assist the neediest New Yorkers. The recent targeting of other safety net programs like Medicaid and SNAP, and the open hostility recently demonstrated toward the homeless population in Washington, D.C., would suggest that these grants are at high risk. The IRS has had its operational budget slashed, and the Department of Education may be wholly eliminated. For this reason, these federal agencies seem likely to drop their grant programs. Where would this leave New York? Unfortunately, the programs I just detailed serve the most vulnerable among us: the elderly, those with disabilities, victims of violence, immigrants, and homeless New Yorkers. Another way to consider federal funding cuts is to think about how they may be concentrated and may undermine particular New York legal nonprofits. Looking at the data, there are 20 legal aid providers in New York that receive 20% or more of their funding from the federal government. To lose that much of your budget could pose an existential risk to those 20 organizations, which provide immigration, domestic violence advocacy, disability support, and general legal services across the state. Looking more deeply at these organizational risks, we see nonprofit providers in Western New York and New York City at particular risk. 5 large providers in Western New York receive between 20 and 27% of their funding from the federal government, which is a large regional concentration of federal support. I see New York City funding at risk because the current administration has threatened to cut all federal funding to New York City because of it is a large sanctuary city. If that were to happen, 27 civil legal aid providers in New York City could face significant cuts. In addition to outright cuts, new federal restrictions are sowing fear and confusion among legal aid providers. Recent grant conditions issued by the Department of Justice and HUD prohibit the use of federal funds for a long list of activities such as community engagement, research, DEI initiatives, issues classified as social justice problems, and programs seen as unsupportive of law enforcement or prioritizing immigrants. In some cases, grants have been simply frozen because providers used words like race or equity in their reports. These grant conditions are expected to be adopted by additional federal funders beyond DOJ and HUD. The chilling effect is real. In their efforts to comply and preserve remaining funding, providers are changing their community outreach and adjusting services, even at the expense of mission integrity. 2 recent federal actions are expected to exacerbate these trends. An August 7th executive order now requires each federal agency to appoint a senior political appointee to approve all grant awards, to ensure alignment with national interest, and it requires that grant contracts permit immediate termination for convenience if the grant no longer advances agency priorities or national interest. A bill was recently proposed that the president indicated his support for that would conduct a new federal census, removing non-citizens from the count. This would skew population data used to allocate grant funds. Cities like New York, Buffalo, Albany, as well as rural New York communities with sizable refugee and migrant farm workers could lose millions in funding due to artificially deflated population metrics. The situation is made worse by growing legal needs across the state. The passage of H.R. 1 on July 4th is expected to trigger waves of need over the next 5 years. Governor Hochul's office estimates that more than 2 million New Yorkers will lose health insurance coverage and an additional 1.3 million will lose Medicaid coverage due to new eligibility and verification hurdles. An estimated 300,000 New York households are projected to lose all or part of their SNAP. When people lose benefits or face confusing new rules, they turn to legal aid. But they will now be met by organizations that are understaffed, underfunded, and overwhelmed. When federal support falters, state support will be more critical than ever. Iola remains steadfast in its commitment. We recently awarded $561.5 million in 5-year general operating grants. This important investment includes built-in increases for providers over the next 5 years. Many of our grantees have reported that these increases will help in achieving pay parity, something that Chief Judge Wilson mentioned earlier. And this is key to stabilizing the legal services workforce across the state. While this support is timely, increased Iola funding has already been budgeted. Our funding will not fill the gaps left by federal cuts. This is yet another reason why continued investment in civil legal services is vital. Moreover, state dollars alone cannot backfill the scale of federal disinvestment we are seeing. Without action, thousands more New Yorkers, low-income families, people with disabilities, seniors, veterans, and immigrants will be locked out of the legal system. We must meet this moment with ingenuity. Iola is trying to do just that through its Justice Infrastructure Project, which boldly seeks to ensure that every New Yorker with a legal problem has clear and timely access to high-quality legal information, advice, or representation. Over the past 18 months, Iola has worked with New York legal service organizations, community-based organizations, national experts, and many, many stakeholders to identify ways to achieve this goal. Through an iterative process, Iola has honed its vision to develop, 1, a state support function for legal services organizations, and 2, enhanced legal information and referral tools for the public. Iola views these 2 new functions as increasing coordination among providers, closing service delivery gaps, leveraging technology, which will ensure broad access to timely and trustworthy legal information. I offer this example of the Justice Infrastructure Project as an example of how government can invest to make services more effective to reach more people. With the expectation of decreasing resources upon us, efficiency is important. With its goal of statewide support, this project seeks to increase effectiveness and resilience of our nonprofit legal aid organizations, which are the best to deploy resources to assist our most vulnerable neighbors. I believe Iola and OCA share in this goal, a resilient civil legal aid system that serves all in need. I look forward to our continued work together in pursuit of this goal. Thank you for your time and for your ongoing commitment.
Thank you. Do we have questions from Ms. Fecco?
Well, I'm going to make a statement, maybe not so much, well, maybe there will be a question. So thank you for your terribly sobering, in fact, frankly, horrifying report shared with us today. It's daunting times ahead, and I appreciate your attention. One of the things that you said was, that caught my attention was that you're going to try to provide information, advice, or representation. You know, and that's because in a time of retrenchment, we may need to look at other ways of just, you know, just providing the basics of here's how you do things. Some of the things the state courts have done in the recent past is, you know, made some of our forums more user-friendly, certainly. We have also allowed limited scope representation, you know, so that, and that seems aligned with what you're proposing. You know, when you can't provide a lawyer or real representation, you can provide other forms of basics that will aid people as they struggle in the times ahead, as we predict they will. Is there anything else that you could point to that we haven't taken a direction as a court system to address these needs we see in the future?
Judge, I think there's a lot more that could be said here. What we're looking to do is not anything necessarily with this project I described. It's not necessarily new. The goal is, can we create some efficiency around how services are delivered? One thing I've said to people is the providers themselves are completely overwhelmed with the clients that they're dealing with. And there's a line out the door. But there's also so many more people wandering around, not knowing that there's a line to get into. And what I'd like to see is a more clear way for people to get that information. There are amazing systems and programs that Judge Richardson's office has been leading, so many initiatives which are fantastic. Part of what we've been doing is trying to gather the examples of what exists and how can we scale it. There are amazing things happening in Syracuse. Buffalo has a hub court. We've got so many things happening. How can we share that information across the state and make it easier for people to find those resources? Another analogy I've offered is every provider has their own way of doing an intake with a client and kind of getting that client in the door. If we think of a house with a lot of windows and doors, that's how people are coming in. But can we, without closing any of those windows, put a big barn door on the front and put some arrows driving people in and make it more efficient for people to be screened for eligibility and routed to the right room for the people who are going to help them? All the housing cases go here, all of the Syracuse cases go there, et cetera. I think there's some ways that we can do better collaboration with what we have. And what we've also done is we've studied and talked to my counterparts across the country and learned about projects that they're doing to forge better collaboration, coordination. And the trick here in New York is we're so big. We have so many providers. We have such a rich community in terms of experience and people. Can we try to get everyone together and coordinate those services to make it a little easier, faster, more efficient, to get to Judge Heck's point, to make it easier for the public? They don't know that they're talking to X organization or Y organization, right? They just need the help.
Chief, if I could?
Please.
Director Fecco, the $80 million projection that you started your remarks with and is a devastating number to all of us, I think. The idea that people are in line, and I've been at a number of these hearings throughout the years, and I agree with you. One of the problems was always notifying people to get into the line, right, to let them know about these services. But the lines that we've already had, we had staff that the testimony was revealing were overwhelmed with cases.
Yeah.
Right? And the staff was working hard and not for a lot of money. The testimony we'd receive at these hearings from the clients that were receiving wonderful services that were life-saving services, right, was compelling. But what I think I'm hearing you say now is, and there's a question at the end of this, is that even if we increased the people in line, the door may be closed. They may be in line for no reason at all. And we may have people that have been working their careers to provide these services in a very dedicated people who have come to this job with an understanding that, yes, they're not making the most money in the world, but they're fulfilling a mission, right? And those folks we may lose them in these budget cuts. Do we have to start thinking about managing a major problem with a devastation in these services from the point of view of the service providers who are going to be out of work and what's left in those offices in terms of, do they need some assistance in how they're managing and coping with the overwhelming work that's the lines out the door for those that are left? Is that something the court system should be looking at and focusing on?
Judge, I think that is something to think about, and part of what I tried to address I tried to keep it to 8 minutes.
Right.
I'm sure I went over. But what I tried to touch on is I think there are going to be existential threats to organizations, and it's not necessarily going to, it's hard to know where it's going to fall. So what I tried to do is looking at who has 20% or more of their funding from federal and identifying locations where that was particularly dense. Western New York is one of them. And I think there could be some real attrition there. And I think we do need to think about efficiency. And what I'm trying to suggest is, and I don't pretend to think that the project I'm describing is going to solve the overall need. As Judge Wilson said, there's $1 billion needed to fill the justice chasm. But we can do things more efficiently. And if we have a line, just to keep with the metaphor, can we have someone working the line and handing out information? Can we, which is the brief advice, helping people with forms that are easier to handle, pulling people out of line, you're in the wrong line, you need to be over here. There's a lot that can be done. And I think it won't solve it. What we need is $1 billion, but we can do better. And that's what I've said to the provider community. There's no one fix here, but we can do better for our neighbors. Before all of this disaster and federal funding came about, we can do better, we should do better.
And all I'm suggesting is the focus on those needing the services is vitally important. An additional focus on those remaining after these cuts are had, those doing the work, who are under incredible pressures day in and day out, that pressure is going to build. It's going to be maybe unbearable because they're going to have all these people that are clamoring for their service, and there's not enough of them left. And that's my concern, is maybe we need to focus there also. It's a lot. It's a lot.
I agree,
Thank you
Judge.
for your testimony. I appreciate it.
Thank you.
Thank you very much. Oh, yes, I'm sorry.
Can I just ask, how do you see the role of state and local bar associations, either as chaperones along the line or in helping to support those who are providing the services?
Thanks very much for the question. IOLA has been a strong partner with the State Bar and many other bars across the state. And I do see the bars being really important partners here. The two examples I can mention just quickly. One is helping with getting people in that line into another line. I think the bars have fantastic legal referral services where you can help connect someone with tax help, personal injury help, other tort help, other types of cases that legal aid doesn't handle. And if we had better bridges between those legal referral service programs that the bars often offer with a bridge between them and legal services, I think that could help dramatically. I also see the bars, especially the State Bar, as being a place that can help, once we kind of build that big barn door that I mentioned, help with the messaging and the pointing people in the right direction and helping to reinforce where people can turn. Can we get a more centralized, number, website, all of that? And I think the bars could be really helpful with that. And of course, the pro bono that so many lawyers do, as I mentioned, 40,000 across the state last year.
Thank you.
Thank you very much. We'll next hear from Nicole Nelson, who is the CEO of Frontline Justice.
Good afternoon, Chief Judge Wilson and panelists. Thank you so much for the opportunity to testify today and for considering this important issue. I am Nicole Nelson, and I'm the founding CEO of Frontline Justice. We are a national initiative that is dedicated to addressing our nation's sprawling and escalating access to justice crisis by empowering a new category of legal helper, the community justice worker, across the nation. Prior to taking this new role, I spent 25 years as a legal aid lawyer and the longtime executive director of Alaska's only legal aid program. And I agreed to take on this new initiative and to lead this initiative because based on my many years of experience in the field, this was the only scalable solution to the access to justice crisis I have seen. So I'm a true believer. And before I talk about this new access to justice innovation that is spreading across the nation in places as diverse as the District of Columbia, Maryland, Texas, Arizona, and California, I want to talk briefly about the size and the scope of the problem. Across the nation, Americans experience between 150 to 250 million civil legal problems each year. 120 million of those go unresolved. And these numbers predate the avalanche of changes and new legal crises that have been part of the hearing today. A stunning 92% of those needs for low-income people go unmet. These are extraordinary, extraordinary numbers. And of course, this has huge consequences on people and communities. Family breadwinners lose their jobs, children can't go to school, seniors can't get medical treatment, family homes are foreclosed upon, and children are taken into the child protection system when they could remain with their relatives or in their communities. And this lack of access also undermines faith in our judicial institutions and our democracy. These numbers also mean that with respect to the civil justice, we are not failing on the margins, we are failing on the whole. And it is widespread and impacts every state in the union, including your jurisdiction. And so while there's enormous cause for concern with respect to the affordability and accessibility of our current civil justice system, there's also much reason for hope. And that hope lies in looking squarely at this evidence and committing to a future that accounts for it. So why is this happening? Why can't people get help when they need it? There are a lot of reasons, but one of the biggest of them is that historically, in thinking about this problem, we've thought about it only in terms of lawyers, and the practice of law has been restricted to lawyers only. And this is a problem because lawyers simply don't scale. They are too expensive for most people to afford, with hourly rates upwards of $350 per hour, and they're very often not in the right places. So there are huge swaths of our country, including much of my home state of Alaska, where there are no lawyers at all. And I understand that this extends to many rural communities in your fine state also. So then what about better funding for legal aid? Yes, absolutely, absolutely. My friends in legal aid, who I spent 25 years as a part of, there is a vital role for legal aid to play. But again, it is vastly, vastly underfunded, and community demand outstrips available resources in every state in this country. Most legal aid providers are turning away. The research shows one person for every one that they are able to serve. And this means they are turning them away not because their cases lack merit, and not because there aren't serious consequences at stake, but and also there are laws that would protect people. They're turning them away for lack of resources. So those of us who have dedicated our lives are turned into gatekeepers, rationing justice, deciding which of our neighbors get the help that all of them deserve. And this is heartbreaking. It hurts those who go without the services, and it also hurts those who have to do the rationing. And it erodes faith in our institutions and when access to the protection of the law isn't available to everyone. And what about pro bono? Again, there's 100% a role for pro bono to play. But just to get 1 hour of legal help for everyone who's in that line to help, it would require 100% of all lawyers to dedicate 150 hours of legal help every year. We are nowhere near that, and it simply isn't going to happen. But the lack of lawyers isn't even the biggest problem here. Research shows that lawyers, legal aid, and judges are only seeing the tip of the iceberg. The judges and lawyers only see the things that people identify as legal problems. But those are less than 20% of overall problems. We are missing the enormous mass of problems that are beneath the surface. people don't see these as legal problems. They see them as just life problems. And oftentimes at this stage, they could be addressed with some really simple legal help, and when left unattended, they escalate with devastating consequences. Traditionally, we tried to drive these problems through referral systems to lawyers, but those who practice in the areas of most need are in short supply. And so it really doesn't have to be this way. Better justice is possible. It is clear that while lawyers and legal aid and pro bono have a very critical role to play, lawyer-only court-based solutions are not enough. And if we accept that we can't do it alone, we can then start imagining other possibilities. And this is where community justice workers come in. Have you ever been helped by a community health aide or another first responder like a paramedic or an EMT? Could you imagine our health system without them? This is what community justice workers aim to be, the legal equivalent of a health aide. They are ordinary people in a wide range of trusted roles within their communities. They could be health aide or social workers, teachers, clergy, librarians, who have been trained and are supervised and supported oftentimes by legal aid organizations to provide simple legal help on issues that would otherwise go unmet. They are oftentimes the people that community members are turning to with their own life problems. And importantly, the fact that justice workers are drawn from the very communities they serve means they are closest to the problems, and they are trusted by those who are seeking help. In Alaska, we developed a justice worker program that both fits our community's needs and leverages our community's strength. We chose this route because we saw strong evidence that it would be effective and scalable and could scale up to meet the needs of our state's people. And the model is showing great promise. To date, hundreds of justice workers have been recruited and trained, and they are supervised by the legal aid organization in partnership with other community-based organizations. They are widely dispersed in 42 different communities, most of which are off the road system, and they are addressing simple legal problems like accessing public benefits and simple wills that left unaddressed would have enormous consequences, and they have been incredibly successful. Recent research showed that justice workers have recovered $23 million in SNAP benefits that otherwise would not have reached the hungry people who needed them. They have a 25-to-1 return on all funds invested in the program, and they are spreading help to legal deserts. This model is exportable. 9 states have already approved regulatory environments that allow justice worker programs. They are Alaska, Arizona, Delaware, Hawaii, Minnesota, New Hampshire, South Carolina, Washington State, and Utah. The Texas Supreme Court, as Judge Hecht has mentioned, has preliminarily approved a program that would allow for justice workers. And 20 more states, including Maryland, Virginia, California, plus the District of Columbia, are actively considering this. Within the last few months, the American Bar Association and the National Conference of State Supreme Court Justices passed resolutions encouraging jurisdictions to explore the potential of community justice worker models as an access to justice crisis solution. So I believe that community justice workers are the better justice that we are looking for. It's a gold standard, an evidence-based solution for scaling justice. And I think it has the potential to get what I think we're all hoping for, which is to assure that everyone has access to the right size, on-demand, effective legal help from a trusted source at the time that they need it. And I look forward to seeing what your jurisdiction might do and how you might lead others in helping us learn how to do this best. Thank you.
Thank you. Let me start with a question. Have you done, or maybe a couple, have you done sort of customer surveys or satisfaction surveys, and how have those turned out?
Yes, we have, and they've turned out very well. So a couple of things. There is NSF research that will be published soon that will show the actual results. But preliminarily, they are greatly received by the public. So they have been well received by those on the other side who are receiving.
So were there questions like, do you think you would have been better represented by a lawyer, or how satisfied were you? Those kinds of questions were asked?
The questions are, were you satisfied? Did you get the outcome that you wanted?
Okay.
And are you happy with the way that you received the service?
And would you like to, if you had another problem, would you go back to the community?
Exactly.
Yeah.
Yes.
So one thing that strikes me is a little interesting, I guess, about I think there's a general reluctance to think that people who are non-lawyers should be doing this, is that in New York State, we have an awful lot of judges who are not lawyers. And so it's a little funny that you think, well, I have to have a lawyer to go into a court, but I don't have to have a judge who's a lawyer.
Sure.
And also, you know, in several places in the state, this is not predominant, but in New York City, and I think in Nassau and Suffolk counties, and maybe also in Buffalo, where traffic tickets elsewhere go to judges, they go to an administrative agency. And as somebody, again, who's not a judge, it's a, you know, administrative agency dealing with something that police officers have written down, and it's an accusatory instrument, but, you know, once again, it's not a judge who's deciding those, really. And so the reluctance seems a little odd.
I agree with you. I would also say that the research shows that really what's effective in making sure that people get quality legal help is really specialization, and so that they have experience in a specialized area, right? So the way that we think about it as a national organization is figuring out how to, I like to think of it as teaching legal procedures and trying to figure out what the right training is to perform a particular legal procedure.
And
then
are there
developing programs for that.
categories you then sort of exclude as, look, this is just not suitable, or not really?
So again, I think I will start from the space that there has been no evidence that certain categories are off limits. But it's a new area of practice, and what we're really thinking about doing is you don't have to eat the whole elephant at once, right? So there's surely lots of low-hanging legal fruit that we can start with and develop training programs that are very targeted at addressing those areas that have high impact need, and then build up on it and see what we learn. And nobody's talking about immediately having people who aren't attorneys filing class action lawsuits or appearing in Supreme Court appeals, right? We're really talking about this huge swath of people that have simple legal problems that need some legal advice and some help, and starting there and see what we learn, and then upskilling from then on.
I just want. First of all, thank you, Ms. Nelson, for being here and for this very interesting and useful suggestion. Let me ask you, what are the backgrounds of the people who you have trained, and on average, how long does it take to bring someone up to speed so that they are ready either to be supervised by someone, or I imagine ultimately they speak to a potential client on his or her own, right? So how long does that take?
So a couple of things I would say. I'm going to speak specifically to the Alaska model, but or the Alaska program, but there are lots of different ways of doing this. So I will just, again, hone this in the example of how the Alaska program works. So the backgrounds of the hundreds of Alaska community justice workers are really varied. It might be a health aide who has a background or a domestic violence advocate. They are also sometimes volunteers. Some are law students. And so there really is no specific background that is required. It's just the capacity to be able to take the training program and do the work under supervision and do it well. So there are 5 areas that the Alaska program started with, and they were responsive to widespread community demand. One was in SNAP benefits, appealing denials of SNAP benefits. The other is representation in Indian Child Welfare Act cases, because our community is, we are home to 229 tribal nations. And already tribes had a right to a representative of their choosing in those hearings that do not need to be lawyers. And so providing training there. Others were in wills, which was specific to a specific need, and anti-debt collection. So really, the training programs need to be specifically fit to the issue at hand. Appealing SNAP denials, we are teaching how to do the due process trainings, and so those took about 8 to 10 hours for someone to complete, and they are asynchronous distance learning on-demand training programs that were used. Now, I want to say this, they've been very effective. Again, our justice workers are doing really great work, but there are a lot of different ways that one could go about doing this. It's not a one-size-fits-all. I think what's great about this model is you can think of it as a way to start meeting the needs of your own community and the specific challenges that are faced there. And some things might be more complicated and require additional levels of training, but there is somewhere to start.
Thank you.
I was going to ask a similar question about who serves, and so that's been answered in part. But one of the things that that the state courts have been doing in some regions very effectively is outreach to clergy. Mm-hmm. And that would seem like also a very likely, because they're people that folks are already turning to for solace, support, whatever, in their community. And do you have a lot of those folks, also participating? Has
We
that been the
do.
Alaska experience?
That has been in the Alaska experience, and also nationally. So Frontline Justice has a national task force that includes who we would think of as implementers, these trusted actors who are not lawyers, but they're the trusted organizations that people go to. And there are a number of faith-based organizations that participate. And when you think about the scalability issue, really, can you imagine one of the AARP is on our National Leadership Council, and you could imagine they train up people to volunteer to do people's taxes, 38,000 volunteers in any given year to help people with taxes. Might those same volunteers be able to be trained to do other areas where there's widespread help? You can see the scalability issue there. One of the how Alaska got started, how we determined who we would target our training programs to, is we did some asset mapping. We wanted to see where the lawyers were. We saw they were all along our road system. And then we also wanted to see who had a bigger footprint in our state and people were turning to for help. And for us, that was the tribally operated healthcare system. It's going to be different in every community, right? But so you might think about how you could map those trusted community actors out, and then think about how you might marry them and partner them with people who have the legal subject matter expertise to provide that help.
I hate to ask this question, but I'm really interested. Do these individuals get insurance?
Yes, so.
And who pays for it?
Yeah. So specific to the Alaska model, Alaska Legal Services, which is the legal aid provider, is insured by the National Legal Aid and Defender Association's insurance company, and you'll hear from April a bit later. But it is covered, so malpractice insurance is covered by those that are affiliated through the legal aid organization. And so by way of you think about, and this is again just one model, there are other ones, these folks are seen as pro bono volunteers for, so again, they're like pro bono lawyers, but they are pro bono volunteers for who are not lawyers by training. And so that's another way to think of it. And they're provided malpractice insurance. Each jurisdiction is different. Some jurisdictions, I understand, don't require lawyers to have malpractice insurance. And so it might come in a different way, but that's how it's provided there.
Are the supervisors, do they have exposure? Do they have insurance as well? The supervising attorneys, whatever the degree or nature of that?
So their cases are, again, they're covered by the malpractice insurance is provided by the legal aid organization, which the supervising attorneys are working for, and so it's covered under that capacity.
Thank you.
Thank you very much.
Thank you so much.
We're next going to hear from Sylvia Duran, who is a client of Sanctuary for Families, and Simone Manasebian, a Chief Program Officer there.
Good afternoon. Thank you for having me. My name is Sylvia Duran. I was 7 years old when I first fell in love. I fell in love with America. That's when I came to this country from El Salvador with my grandma, with nothing but the clothes on our backs. I remember being woken up in the middle of the night and told to get in the trunk of a black Lincoln Town Car. The ride on dirt roads in a hard metal trunk almost made me forget that I hadn't eaten in days. My grandmother laid me on top of her so I wouldn't feel the bumps. We crawled under fences and rode buses with people carrying guns bigger than me. I was so thankful when we finally made it. On that day in December 1992, we were finally home. I picked up the English language right away, and I graduated from high school. My mother had dropped out in the 6th grade, and I watched how hard she worked 7 days a week as a maid just to put food on our table. She and my grandmother taught me never to give up on my goals and to keep pushing forward. The progress stopped when I met my children's father. By 19, I had my first son, and by 26, I had 3 children. From the beginning, my husband was extremely controlling. I wasn't allowed to continue my education. He jealously monitored my every move and demanded absolute obedience. He became controlling and abusive to the children, too. We were terrified of him. My fear intensified when he brought a gun home. One time I left the house after an incident of abuse. He got in his car and followed me. When he caught up to me, he lowered his window, pointed his gun at me, and fired in my direction. Thankfully, he missed me. Then he said, "Get in the car." After that, I tried to do everything that he wanted. In 2016, after yet another terrifying incident, my children were ages 10, 7, and 4. My husband had been drinking. He ordered me to go inside from the porch because there were men outside supposedly looking at me. When I hesitated for a second, he grabbed a beer bottle and hit me in the jaw. He dragged me inside, held me down on the living room floor, punched me in the face, covered my nose and mouth to keep me from screaming, and strangled me as our children watched. When our oldest tried to push him off of me, his own father turned on him, bit his own son in the arm, and punched him in the head. As I called 911, he grabbed the phone from me, but I screamed out my address. The police came and arrested him. While the criminal case was pending, my husband threatened if I cooperated with law enforcement, he would sue me for custody and win. He reminded me he was born in the US and had a good job and made good money, but because I was an immigrant, I was a nobody. He said I would never see my children again, and I believed him. I stopped cooperating and I went back. He hated when I found work as a waitress. One drunk night, he threw my clothing out the window, threw me on the bed, and started punching me in front of the children. I called 911, but by the time the police arrived, he was gone. That night, after more than a decade of abuse, I fled with the children. At first, we stayed with my mom, but my husband began stalking us there. After we fled to an emergency domestic violence shelter, he found us and waited outside the shelter filled with rage. They relocated us. We spent almost 2 years in this shelter system. We lived in a single room, shared a kitchen and bathroom with 6 other families, dealing with inspections and curfews. When he could no longer physically stalk me, his stalking took a different form. He hacked into my emails and began sending explicit pictures of me he had secretly taken while I was sleeping to all my contacts, friends, family, coworkers. It was humiliating. I reported it to the police, who told me about the Family Justice Center. That's where I met Lindsay Song, my attorney at Sanctuary. With her support, I was able to face my greatest fear, that my abusive husband would take my children from me. Lindsay filed petitions and an order of protection and custody. My husband cross-filed for custody. The legal battles lasted 7 long years, often feeling like a continuation of abuse. Even though I had evidence of his abuse and stalking, my credibility was continually in question. I was disappointed by how little attention the judge paid to the violence the children and I suffered. I now know that my case had many risk factors which the court should have paid attention to. The stalking, strangulation, extreme controlling behavior, the threats with the loaded gun. These incidents all indicated a very high risk of lethality, but no one except my lawyer seemed to understand that danger. The threats even continued in the courthouse. While waiting outside the courtroom, my husband said, "You know that gun? I still have it." My husband's attorney claimed that I was inventing the abuse in order to alienate my children from their father. He also claimed that I was delusional. It wasn't until the judge interviewed the children that he began to understand the severity of the abuse and the danger we were in. Eventually, I was awarded full custody and an order of protection. My husband does not have any visitations. While in the shelter, Sanctuary helped me earn a billing and coding certification, and I also took courses in nursing. In 2018, I moved into a small apartment. In 2022, I applied to New York Hospital Police. I now work in the detective unit and was just offered my promotion to sergeant. I am one of the lucky ones. By the time I was in court, I was a United States citizen. Today, undocumented survivors are too terrified to come to court and pursue the protection they urgently need. So many do not have the kind of help and protection I received. The holistic help my children and I received from Sanctuary for Families changed our lives. Today, my older son is in college. My middle son is in high school, and my daughter in the 8th grade. They are all thriving, and I couldn't be prouder. My biggest gratification is my ability as New York Hospital police officer to provide victims with the empathy and assistance I needed in my own journey to safety. Your Honors, I sincerely thank you for listening to me. I pray that this hearing spurs concrete actions to take our court system more responsive to our needs and those of our children. Thank you.
Thank you, Ms. Duran. Thank you for sharing that with us.
Chief Judge, Your Honors, Madam President, it's an honor to be with you here today. Thank you for providing Sanctuary for Families with this opportunity. Sanctuary for Families is New York's largest wraparound service provider for survivors of domestic violence, human trafficking, and sexual assault. Serving deeply vulnerable clients for some 4 decades, we are acutely aware of the struggles abuse survivors confront accessing justice in the legal system. 2025 has been a devastating year for marginalized populations under the new administration, the new federal administration. Meanwhile, rates of intimate partner violence have been on the rise. 15% of Sanctuary's budget is comprised of federal funds, either direct or pass-through, which support essential legal programs, including our Pro Se Family Court Project, Title IX assistance to victims of campus sexual assault, and trafficking victim legal services. This year, we have seen very few funding opportunities from the relevant federal agencies, DOJ and HHS, and all issued RFPs require sign-off on new certifications on activities including services to immigrants, DEI initiatives, and inculcating or promoting of gender ideology. Our JCLS funding currently supports 25 attorneys and paralegal administrative staff specializing in housing, public benefits, family law, matrimonial, child support, custody, and immigration matters. In fiscal year 2025, this funding supported legal services to 6,318 clients in 10,662 cases. We significantly leveraged this through our pro bono work with over 1,000 private lawyers. This funding is all the more vital to support legal areas where new federal restrictions limit or prohibit service provision. Immigrant clients, no matter their status, are terrified of detention and deportation, extremely wary of appearing in person, at court, or even at our offices. Clients are now far more likely to be apprehended, detained, and deported by immigration enforcement officers, even as their cases penned before the Immigration Court or USCIS. Immigration legal fees have exploded. The fee for a BIA appeal, previously $110, is now $900. There are fees for all previously free humanitarian applications. For instance, there was no fee for a trafficking survivor's T visa filing. Now it is $1,000. And because there is well-founded risk of arrest associated with any in-person court appearance, immigration attorneys are putting in notices of representation for far more clients, greatly straining their capacity, because clients can attend their hearings virtually if they have an attorney. From the perspective of grant reporting, in this grim new environment, immigration attorneys urgently need to be able to provide services without funders expecting traditional indicia of success, such as case outcome. IPV is the cause of homelessness for some 40% of families in city shelters. If a survivor is able to separate from their abuser, they often cannot afford rent. Courts proceed with eviction without regard to these circumstances. The Right to Counsel program in New York City, designed to offer assistance to tenants in these circumstances, is increasingly unable to provide representation to abuse survivors. Housing subsidy programs are extremely difficult to access from HRA. With the acute affordable housing crisis and the difficult, slow, and confusing bureaucracy around subsidies, survivors feel forced to remain with abusers especially when they have dependent children. Given the impending sharp cuts to public benefits, we must educate New York City residents and provide legal advice on changes to their government benefits, dispel misinformation, and provide clear legal advice on eligibility, as well as assist survivors in applying. As social safety net disappears, IPV survivors increasingly need emergency food while waiting for benefit applications to be processed, and for those who are no longer eligible for benefits. The federal funding cuts will particularly affect humanitarian immigrants, refugees, asylees, T visa holders, VAWA self-petitioners who are currently eligible for most public benefit programs without a waiting period, but will soon be excluded from Medicaid, SNAP, Medicare Part A, and certain tax credits. Lowering federal Medicaid matching rates for emergency services for immigrants may create incentives for states to restrict eligibility for immigrants, including non-citizens that have temporary protected status, DACA, U visa holders, and undocumented individuals. Since most sanctuary clients fall into these immigration categories, the impact of these federal cuts will be catastrophic, creating situations where they feel forced to return to abusers. And all of this underscores a related issue. JCLS and many other legal funding sources do not address this issue. The critical need for intensive case management. Much of the non-legal advocacy work, such as advocacy for benefits, subsidies, referrals to shelter, mental health, medical, dental, language-appropriate or other specialized services, emergency food, financial assistance. This should be done by skilled case managers. For clients in crisis, the ability to move forward and effectively pursue legal cases is contingent on addressing these needs. When attorneys are addressing clients' crisis case management needs, their caseload capacity is hindered, providing legal assistance to fewer vulnerable New Yorkers. We respectfully urge JCLS to consider funding case managers. Finally, to compound the stress on our clients and attorneys, we have seen an uptick in retaliatory legal filings by abusers, requiring additional legal work to file motions to dismiss and potential court appearances. Some of these filings are against the lawyers themselves, personally, and that has an effect on our insurance rates. That has an effect on our general counsel, and it's quite a troubling trend that we're seeing. I thank you for providing this opportunity to speak on this important issue, and I thank you, Ms. Sylvia Duran, and all the fantastic survivors who not only have stuck through 7, 9, 10 years of representation in Sanctuary for Families and other organizations, but who came now and share with us their unique experience and perspective. And thank you for your courage, Sylvia.
Thank you. I have no questions, but two observations, I guess. One is that, Ms. Duran's example really illustrates, and I don't mean to minimize the amount of work Sanctuary did, but if you think about the cost of the work done to protect her and her family and the benefit from it, you can see how that 1 to 5, 1 to 10 ratio really plays out. I mean, you have a great job, you have a great career, you have a great family, you have children who are doing really well for what really was a modest investment that if it had not been made could have likely wound up in really serious tragedy. And I take the point that this doesn't happen 100% of the time, it doesn't happen maybe 50% of the time, but it really illustrates that. And the second thing is that the 7 years is unconscionable. And it really, it goes back to a point that Chief Judge Hecht made, that when people have faith, if the courts can do things better, if they can reach that same result but can reach it in 2 years or a year and a half, it is so much better for the public belief in the court. And so we have to do better.
Yes, and Your Honor, in the immigration cases, we're seeing cases that are taking 9 years. We just won an asylum case last month of a 9-year pending case. So
That's a federal case, I assume.
Of course. Of course. That was my point. So the federal courses are taking even far longer. Yes.
Yes. I had a question. First of all, let me just initially note to Ms. Duran, thank goodness that, that you're thriving. But there are so many other survivors who are, I'm sure, struggling, after going through such an ordeal. But I have a question, counsel, for you. Our court system is one which is, some have referred to as antiquated here in the state of New York. You go to family court for one matter, right? You go to Supreme Court for your matrimonial. You go to a different Supreme Court judge now for your criminal matter, or perhaps if it's a domestic violence or criminal court matter. And I know we have some domestic violence courts. But to what extent does the antiquated New York State court system further impinge on victims such as your client, who I would imagine had to shuffle from one court to another, days missed of work, childcare issues, yet the state continues to go on with this system that doesn't seem to take into account that victims have to go through so many different judges, right? I'm just curious what you think about that.
This is one of the feedback that we've received from survivors and survivor listening sessions that we've had. But, another related feedback is going through one attorney after another because of the retention problem. And that's something that I heard you speak about. I think it was Judge Whalen asking about that today. And it's such an important point because what the clients are telling us is we have to tell our story over and over again. We feel re-exploited. And I think that that's a huge problem as well.
I don't have a question, but I have a statement I want to make. I had the privilege of reading through your really, truly astonishing background. I've heard now your passion in the work you do. I've heard your client who benefited from the work. And I just want to say thank you. And it is an honor to share this space with you.
It is an honor to be able to do this work, Your Honor.
Thank you.
Thank you.
We'll next hear from April Fraser Kamara, who is the president and CEO of the National Legal Aid and Defender Association. Welcome.
Thank you. Good afternoon. Chief Judge Wilson, Chief Administrative Judge Zayas, our presiding judges, and also State Bar President Sweet. It is truly, we are grateful at NLADA to have the opportunity to stand before you today and share with you our perspective. I'm April Fraser Kamara, President and CEO of National Legal Aid and Defender Association. And NLADA actually has its origin stories here in the state of New York. NLADA was founded actually by bar attorneys in New York City who was concerned about access to legal services for people who were migrating through Ellis Island. So our origin story actually is around concern about the immigrant population who was coming to America and whether they could afford access to counsel. And so it is our pleasure here today to come 114 years later to stand before you and talk about the state of access to counsel in America and specifically the impact on the state of New York. At NLADA, we represent more than 700 organizations that provide both civil legal services and public defense. But in addition, we also, in our membership, we include the clients that we serve. We are a unique organization and also a unique national voice. And I hope that my perspective here today will be helpful to you as you decide very important, urgent issues concerning access to justice in America. So my testimony today is going to focus on the federal cuts and the impact on low-income New Yorkers. And I will really try to focus in to be complementary and not duplicative of what you have already heard today. So I want to focus on two areas. The first is around the policies and practices that we are seeing in Washington, D.C. from the federal administration regarding the administration of federal programs. And what is that direct impact on low-income communities and how it relates to their need for access to civil legal services. And then the second issue that I will focus on today is the actual funding issue and the concerns that we have around the federal cuts to support access to justice in America. So first, you all have heard about the federal policy decisions that are being made in Washington, D.C. They are really decimating the social safety net and increasing the issues around homelessness, food insecurity, truancy, unemployment, and even our battle with combating violence. Specifically, the Congressional Budget Office estimates that the health care provisions in the One Big Beautiful Bill Act is estimated to cause 10 million people to lose health care coverage in America by 2034, 1.3 million in 2026 alone. And specifically, when we look at the impact of that legislation, they are also estimating that 300,000 people will see a decrease in access to SNAP benefits, and the number could be even higher. The Center for American Progress estimates that specifically in the state of New York, it could impact 317,000 people who would face immediate risk of losing SNAP benefits. And so, as you can imagine, when communities face these issues, they turn to civil legal aid for assistance. The changes that we're seeing on the federal level not only will increase the need for civil legal services in America, but it will also, those issues will also impact the organizations who are serving. Justice Whalen, you raised a very important point, and I would like to focus my testimony today on the impact of the people who work in civil legal services. One issue that we're closely monitoring right now is actually loan forgiveness programs and the impact that it is going to have on our members' ability to recruit and retain people to do this work. As a former public defender, I know how hard it is to want to do the work and also want to provide for your families. So not only are we facing increase in the need for people to do the work, but the ability of the staff members to be able to do this work and provide for their families is a real concern. And so as we look at the issue, it's not just looking at the increase in the need for services, but also will we be able to retain people to do this work. In addition, when people lose access to programs and safety nets, they actually, when people lose access to safety nets, they also face the complexity of the impact of the new federal regulation schemes. So as we look at the changes in federal program, there will be a need to educate the public around these changes in order to make sure that people fully understand how the changes impact them. In addition, you heard about the potential cuts to legal services program, but I actually want to focus on another issue beyond just legal services. We actually took a look at the changes to other federal agencies who actually have programs to help people navigate federal systems, such as Social Security. Specifically, we have been able to see that programs like Social Security that typically have the staff capacity to help the American public navigate the system without the need of legal services, the cut in staff capacity at those federal agencies will take away the very limited assistance that was available through those programs. And that will also impact the need for more civil legal services. The reduction in federal funding for legal services is dire enough. We already have heard the numbers around 92% of people who try to access civil legal services are turned away. But there are also growing concerns around the uncertainty about our civil legal aid programs' access to federal programs based on the new terms and conditions. Many of the grants, as you heard, are being conditioned on issues around excluding immigrant rights, excluding diversity and equity and inclusion, and community outreach. Legal aid, our community, is rooted in certain values. And what we hear from our members is that they are having to make the very difficult decisions of whether or not they hold on to their missions and their values, or whether to continue to receive federal funding. And these are very difficult decisions for legal service providers to make. They're charged with tailoring their outreach and their services to many of the communities who have the greatest needs. They are also striving to try to figure out, with the loss of federal funds, how do you continue to maintain and build the trust in the communities that are being targeted and further marginalized. This forced decision that many programs are having to make not only corrodes the mission integrity, but it also impacts staff morale. We are hearing from our members the very difficult challenges that management is having to face as they have to explain to their staff around difficult decisions of complying with new federal regulations in order to keep funding. We're also seeing on the federal level a chilling impact of pro bono engagement, all of which affects the ability for our community to provide quality services. Most importantly, it creates the impossible paradox of seeking funding to provide services at the expense of those who most need those services. The federal government policy is really pulling the rug out from under many families in America and slashing the services that they need to get back on their feet. Federal policies and practices alone, federal policies and practices already are creating additional needs for legal services and threatening funding that will leave tens and thousands of New Yorkers unable to defend against eviction, benefits, and to protect their families. I urge the Commission today to really deepen your commitment to legal services and really strengthen the safety net that's needed in this moment. As we heard from Justice Heck, equal justice is not a partisan issue. At NLADA, we have been able to build bipartisan support around the fundamental issue of every person who comes into contact with the legal system in America should have a fair shot, regardless of your income and your zip code. Equal justice is a promise. It's a promise that is written in our nation's founding documents and carved into the stone of the U.S. Supreme Court. And New York has led the way in really exemplifying what equal justice means. And we urge you to continue to fight to make sure that New York is a leading voice in our pursuit for equal justice. Thank you.
Thank you.
President Camara, thank you for your testimony, and appreciate you laying out all the difficulties. You heard the testimony from Nicole Nelson previously, and I'm wondering how is the prospect of using community justice workers being viewed by other legal aid providers nationwide? Yes. If you could, I know it's a little off topic about what you were talking about, but I'm wondering how, what the view is of the legal aid providers.
Absolutely. So as you can imagine, an organization with membership around the country, there are various views around the issue. However, overall, our community is supportive of exploring the possibility. We think every jurisdiction has to take a very careful look at the program and how it can meet your needs. There are a few things, and we're about to issue our statement around specifically best practices. So of course, we're concerned about making sure that the quality of representation is not impacted as we look at different innovations. And so regardless of how a jurisdiction is going to explore the issue, the safeguards around making sure the community is protected is our greatest concern. But the really good part is that we actually asked our client community, what do you think about community justice workers? And similar to what you heard from Nicole, the clients said, we want help. So we are not, sometimes we get, really mired in the details, but the client community is saying if people can help us and it not dilute the quality of the representation, we are open to solutions. And so I think it's a great tool, a great resource, but I think every community has to figure out whether it's right for them.
Thank you.
Let me ask, do you think there's a consensus or leaning among your members about whether, assuming you were to use something like community justice workers or some other paraprofessionals, that your members would prefer to have them within their own organizations or external?
That's a really good point. One thing that we hear from our members is the concern that community justice workers should be embedded within civil legal aid offices. There's great concerns about this being a model that can stand alone without proper supervision and regulation. And also we are very concerned that it should be used to meet the gap and legal services for low-income communities, and not as a business model. We want to make sure that if you use this as a tool, you actually serve the community that it is intended to serve. So just making sure it's not a backdoor way to achieve other profitable ways that it could be used. So we're just very concerned about making sure it's being used to serve those who need the help the most.
Can I just follow up with one? So when I was a legal aid attorney and I went to speak to a client and I identified myself as legal aid, they said, I don't want a legal aid, meaning AIDE. I want a real lawyer. Mm-hmm. Is there a risk with that in using community justice workers?
I think that we have to really look at the history behind people's response to that. And I think you will continue to have to do the work around building community trust. But we have seen that if you actually, let me give you a really concrete example. How many of us, as a former public defender or legal aid attorney, had a brilliant front desk secretary who could have been an attorney, but for maybe they didn't have the support to go to law school, but they were brilliant, right? Sometimes they would catch the typos in your motions before it went out of the door. They would know how to relate to clients in a way that we may not have had that ability. And so we have seen people use this model to really a workforce development pipeline for those brilliant colleagues that we have worked alongside for many years. Even as I hear clients tell their stories, many clients can tell their stories much better than we can. And so while, we will constantly have to combat the concern about we're providing people a lower level of services because it's free, it's also tremendous opportunity for us to create a pipeline for people who have lived experience to come work alongside us and do this work. And so I think that outweighs the risk of concern about damaging the reputation of legal aid providers.
Thank you very much.
Okay, thank you.
Now I'm going to hear from Professor Carl Gershenson.
Good afternoon, members of the Permanent Commission. It's an honor to be here, and honestly, a little intimidating too. Finishing up this first set of presentations, hearing all of the really powerful and excellent testimony from my co-panelists. So thank you for having me. I am Carl Gershenson. I'm director of the Eviction Lab at Princeton University. We are an academic research center dedicated to studying the causes and consequences of housing insecurity in the United States. I'll start my comments by talking about how the impending cuts in federal housing support and poverty spending will affect renters in New York. According to the National Low-Income Housing Coalition, New York State is the third least affordable state in the nation. Fair market rent in the state is around $2,100 for a one-bedroom apartment, meaning that a minimum wage worker would have to work 105 hours per week to afford it. And that's a one bedroom, so we're not talking about parents here. Also, according to the NLIHC, about 3/4 of the lowest income renters are severely cost burdened, paying over 50% of their incomes towards rent. Another way to look at this, which is calculated by the Harvard Joint Center for Housing Studies, estimates that the typical renter with income below $30,000 a year has only $250 left over each month after paying rent. And earning $30,000 a year, that's about 20% of American households with $250 left over each month after paying rent. Households with such thin margins are one unexpected expense or one income shock away from an eviction. Given that many of these households are already currently receiving federal housing support, the withdrawal of this support will certainly act as just such an unexpected income shock that can push them over the edge into eviction. New York State already has an eviction problem. It has an above average eviction rate for the country, around 8 or 9%. National average is around 7%. That's 7 eviction filings per 100 renter households. It could be a lot worse, given how unaffordable New York State is. But New York has a relatively strong suite of tenant protections that keep the state's eviction rates lower than much more affordable states, like those in the Sun Belt, which also have much higher eviction filing rates. In New York City, which obviously has some of the highest housing costs in the state, these incredibly high housing costs are counterbalanced by an even stronger suite of tenant protections. So that, remarkably, New York City has a below average eviction filing rate, even within New York, about 4%, 4 eviction filings per 100 renter households. This is 3 to 4 times lower than the filing rate seen in much more affordable cities like Memphis, Tennessee, or Richmond, Virginia. But these rosy top-line statistics obscure serious problems. There are pockets of filing rates across the state that are well above the national average, from the Bronx to Erie and Niagara counties in the west, Albany, Rensselaer, and Schenectady counties in the east, and Suffolk County on Long Island. And in New York City itself, the low filing rate exists in part because there are so many higher income people who remain renters in New York City. Anywhere else in the country, they would be homeowners. They would not be in the denominator as we calculate eviction filing rates. In fact, the 2023 New York City Housing and Vacancy Survey reveals that 45% of households in market rate rentals earn over $100,000, as do 30% of households in rent-stabilized units. So whenever you hear anything about the experience of the average New York City renter, remember that that statistic contains a whole lot of high-income households, which really tends to mask the magnitude of the pain being felt by renters on the bottom of the income scale. Evictions are ultimately harmful to the households that experience them. Eviction is a cause, not just a consequence of poverty. At Eviction Lab, we have research establishing that evicted people are more likely to lose their jobs, more likely to lose access to public benefits like SNAP. They experience extended spells of housing instability well beyond the discrete event of the eviction. They are likely to move to substandard housing, generally in neighborhoods with higher poverty and higher violence than the ones that they were evicted from. Eviction Lab research has also shown that eviction harms health, with consequences including early mortality. Pregnant women, who have among the highest risks of eviction, are more likely to experience adverse birth outcomes like premature births and low birth weights when they are evicted. Nearly half of all evicted households have children in them, whose education is severely disrupted by these evictions. Furthermore, evictions in high-cost states like New York are uniquely damaging because the risk of homelessness is so much higher here. Charlotte, North Carolina might have an eviction rate twice as high as the Bronx, but Charlotte also has a vacancy rate that is 15 times higher than the Bronx. When you get evicted in Charlotte, you have a good chance of finding somewhere to live. But the Bronx had a vacancy rate in 2023 of 0.82%. When you get evicted in the Bronx, there's a very good chance that you're going to end up homeless. A 2014 study by the Robin Hood Foundation found that 25% of New York households receiving an eviction ended up homeless. That percentage is likely much higher now, given increased rents across the last 10 years, increased rates of homelessness across the last 10 years. Increases in evictions and homelessness will increase burdens on nonprofit service providers and on civil legal services at the same time as federal funding cuts are undercutting these organizations too. Done right, civil legal aid can reduce the frequency of and the damage done by evictions. Even when legal aid is unable to avoid an eviction, harm reduction can occur when counsel for both parties reach agreements for a tenant to vacate without having to issue an adverse judgment. Agreements to vacate can also give tenants more time to vacate the apartment than is mandated by statute. This extra time makes it easier for the evicted tenant to search for a new apartment, again, dramatically cutting down on risks of homelessness, having to move into substandard housing, or having all of your material possessions set out on the curb and hauled to the dump. There are several strategies that can be used to reduce the costs associated with civil legal aid. In places like Charleston, South Carolina, legal aid groups work with the courts to schedule all eviction cases in regularly occurring blocks. Legal aid lawyers show up at one courthouse on Monday, another courthouse on Tuesday, and so on, allowing even a relatively small team to provide blanket coverage to all tenants who show up at the courthouse. Secondly, programs like those in Delaware are showing how non-lawyers can provide support to lawyers when their caseloads become too heavy. Delaware's program trains qualified tenant advocates to complement legal aid working on eviction cases. Scheduling housing cases in blocks, as suggested above, makes it even easier for lawyers and tenant advocates to support each other, as the lawyer may cover the courtroom whenever any legal issues come up, and the tenant advocates work with tenants waiting in the courthouse hallways. Federal funding cuts will undoubtedly hurt low-income renters already living with no margin for error. Investments in civil legal aid and the expansion of the role of non-lawyer advocates can help these households stay above water. Left unassisted, too many of these households risk falling deeper into poverty and into homelessness. Thank you.
Thank you. Questions? I have one for you that's a little off topic, but since you are the head of the eviction lab, you may have done some research around this. And the answer may not even be homogeneous or equally applicable within New York State, but if the legislature imagined that they had some large amount of money, say $500 million, to devote to housing, and their choices were either to use it to provide legal representation for everybody under, let's say, double or triple the poverty level, or to provide housing assistance payments, how would you spend the money?
Am I going to get security when I walk out of here?
We can provide that, actually.
No, I mean, I think that.
Yeah, let me before I'll give you a second to think about it too. So, and this is just my own personal perspective, the ERAP monies during COVID really avoided a lot of evictions at a time when eviction would have been catastrophic for varieties of reasons. And that made me wonder, if we had more money, what is the best way to spend it? And there is pending legislation that's been introduced and it hasn't gone anywhere to provide a statewide right to counsel for people under a certain income threshold. The city legislation isn't exactly right to counsel, it's access to counsel or something that was heavily negotiated that wasn't quite get all the way there. And I think the statistics is maybe half of the people who are facing eviction in the city have counsel and half don't.
Right. So there's a lot of different ways that I look at this. I mean, so on the one hand, 90% of evictions or something like that are filed for non-payment of rent, where the best legal aid can do in those conditions is help you come to an agreement with your landlord, right? In a lot of cases, those are tenancies that are probably going to end unless you have emergency rental assistance. But that said, I don't think that you would want to put all of your money into the emergency rental assistance basket because, like, if you look at evaluations of the ERAP program, one, a lot of money did go, like, a lot of evictions, even after they're filed, might resolve on their own, even without the benefit of emergency rental assistance, especially in New York State, which there is a right to cure the eviction, I think, up until the writ is served. So there's a lot of resourceful people who are able to resolve the eviction without the help of emergency rental assistance. So I think that you need civil legal aid to act almost in a triage capacity to figure out what the best, how best to serve the clients in front of them, right? There are some people who have experienced a short-term income shock. And if you give them ERAP and you give them civil legal aid, you're going to save that tenancy, and they don't need any help, for hopefully never again. There are other people who maybe something about their housing situation or their income has permanently deteriorated. Emergency rental assistance is just going to push the eviction off for a few months. You need civil legal aid to identify that and help them come up with a solution that is going to be more permanent. So I think that in order to responsibly shepherd resources, you really do need civil legal aid there, sort of acting as conductors for the emergency rental assistance programs.
Thank you. Thank you very much. We are running a little behind, which is great because it means we've gotten more information than we planned. But let's maybe take a break till 10 past the hour and reconvene then.
All please rise.
Welcome back. We are now, I think, going to hear from Christopher Fox and Rachel Chazen-Halperin.
Okay. How you doing?
Good. How are you?
Good. Good afternoon. My name is Christopher Fox. I want to thank you for letting me speak regarding the need for free civil legal services. Without these services, me and my daughter will probably be homeless or living in a homeless shelter. My daughter is 4 years old. At the time, I was in the middle of a situation where I couldn't necessarily, I didn't know what to do as far as how to go about getting services for my living situation. In order to create a stable life for her, I work multiple jobs. I work at Chipotle, and I worked at Marist College at the time. When I got the chance to get to my apartment, it was 2023. I was able to pay $925 a month, so it was very exciting for me to get into that affordable housing. I was shocked when I received papers of eviction because I didn't know what the grounds for my eviction was. I go to work, come home, have my daughter for a certain amount of days at a time. So I didn't know what to do at the time. So I got some advice from my mother, and she told me to go to legal services. And I came here, and from the first day I came in here to the offices, it was just nothing but help. As soon as I walked in here, it was just, I felt like relief because I had people here that was willing to help me, and I was willing to go to bat for me and make sure that I wasn't subjected to eviction for a misunderstanding or my daughter's minor noises, you know. I learned while we were preparing the case that my lawyer learned while he was preparing for the case that the basis of the noise came from my daughter moving around in the middle of the night, trying to come to me or find me in the middle of the night or had to use the bathroom. And at the time, she was 2 years old. She was in the middle of potty training. There was really like, I didn't know what to do other than not have her with me. So my attorney just helped me prepare like for trial, and was able just to get past be able to get prepared for the trial that we had to go through and stuff. And my landlord was not open to no other options other than me leaving my apartment. So my lawyer just did whatever he could do to make sure that I wasn't able to leave my apartment. A few months after the trial, the judge responded and said that I was able to stay in my apartment, dismiss the case. And I know if it wasn't for legal services, I wouldn't be able to, I don't know what I would do right now if it wasn't for legal services. It wasn't for the team that came together and helped me and gave me enough confidence to see this through. So I'm like super grateful and in debt to legal services just because they took initiative just to help me, you know, just be able to stay in my apartment for an extra year or so, like until I'm able to figure something else out. And I wouldn't know what to do without legal services, honestly.
Thank you. I've actually got a bunch of questions for you, if you don't mind.
No problem.
So are you still in the same apartment?
Yes, ma'am. Yes, sir.
Okay, that's good. So, and has the landlord been giving you any trouble since then, or are you okay?
Not necessarily trouble. It's more so like she actually works in the building now, so I kind of see her more than I used to. But for the most part, I haven't been given no reasons to be on her radar.
Yep. And do you think really her reason was that your toddler was making noise walking around, or that she had some other reason? You don't know.
To be honest with you, prior to that situation, I had another situation where I had to come to legal services. I personally feel like the noise, it was just fabricated. Like I live in a building, so people live under me, below me, but under me and above me and like side to side. So I was under the impression that I was making too much noise for, like she said, I was disturbing multiple neighbors, and I'm thinking it's everybody around me, and come to find out it's just the person below me who heard my daughter's footsteps. And I guess she was real determined to get me out because there was no explanation behind it other than this: you have to leave. It was straightforward. She wasn't really lenient at all. At a point in time, she just wanted to get me out of the apartment, and I feel like I had no other choice but to come here.
And so you said your mom is the one who told you about legal services. Do you have any idea how? I mean, you hadn't heard of them before?
No, because this is my first apartment on my own. So when I was kind of like defeated. I was honestly just like, I got to leave. My mom said, you don't just have to leave. There's ways you can go about this. And me being, at the time, I was about like 25. I never had an apartment before. I never had to go through this. So I'm just under the impression that if they say I have to go, I have to go. And so I didn't know what else to do at the time.
And do you know how she knew about legal services?
My mom, if I'm not mistaken, my mom probably had to go through certain things herself around my age before, she was stable, I guess. So there's just, when I brought it up to her, the first thing she said was go to legal services. Like, it wasn't even an option, anything else other than just to go down there and see what they say.
Yep. I don't know if anybody had questions? Nope. No? Thank you very much. It was great hearing from you. Thank you for taking the time.
Thank you.
Really appreciate
it. Thank you.
Welcome.
Good afternoon. Good to see you all. I want to thank Mr. Fox for his courage in sharing his experience with us so that we can highlight the importance of civil legal services in helping families stay together, safely housed in affordable housing, and stable in our communities. It also illustrates the absolute necessity for tenants whose most basic and essential necessity is in jeopardy, the roof over their family's head, to have an attorney who can zealously represent them in eviction proceedings to assert all of their legal rights and defenses. In 2024 alone, attorneys for legal services of the Hudson Valley handled over 12,000 cases affecting over 21,000 vulnerable members in our community whose basic necessities were at stake. Nearly 3,000 cases were for seniors, 1,600 for victims of domestic violence, and 3,700 were for people who identified as having a disability. We are grateful for our JCLS funding, which supports all of this work, and especially now as our federal funding is on the chopping block. As a recipient of the Federal Legal Services Corporation funding, we are closely monitoring the federal budget negotiations. LSHV receives $3 million in LSC funds, and losing this funding would require us to reduce our staffing and cut back on overall services. Moreover, our LSC funding comes with many restrictions, including on the types of cases, income limitations, and immigration status of our clients. In contrast, the flexibility of the JCLS funding enables us to provide holistic civil legal services to those in need and support clients and casework broadly. This is more important now than ever as the legal landscape and priorities for our clients and communities shift rapidly depending on the government's area of focus and policy agenda. Families living in poverty in our region suffer disproportionately because of inequities in access to healthcare, technology, education, and other resources. Indeed, justice is also a resource that low-income and vulnerable communities are too often unable to access without the assistance of civil legal aid. Our neighbors who cannot access justice experience devastating consequences, including homelessness, living in apartments in disrepair, forgoing important medical care, domestic violence, and having to choose between feeding their children and paying other bills. These inequities underscore the essential role that civil legal aid plays during this historical moment and how it can be transformative in maintaining vulnerable communities' health, well-being, and safety. Access to civil legal aid continues to be a lifeline for people facing the loss of basic necessities and keeping our neighbors healthy and thriving. It plays a transformative role in people's lives. Thank you for the opportunity to testify today to highlight the essential role of civil legal aid and access to justice, and thank you for securing JCLS funding to support civil legal aid at a time where federal funding is uncertain.
Thank you. Questions? I think I have one for you. Do you have any, not particularly about Mr. Fox, but using his case as an example, do you think that the fact that when you intervene for a client, particularly let's say in a housing case, and the client, the tenant remains, that the fact that the landlord knows that you are there has some salutary effect going forward?
Absolutely, absolutely. And I think Mr. Fox's case is a real example that there were several benefits to us being in the case. One, the landlord saw, and the landlord's attorney, who is an attorney who represents a lot of landlords in our region, saw the extent that we would go to fight for an attorney, to fight for a tenant, that we would have a full trial, witnesses, motion practice, and we won. And it also showed the judge on the case the high level of practice that Civil Legal Services has, that we don't just settle cases, that we will, fully assert and zealously advocate for tenants. And so that when tenants are represented by Civil Legal Services, we mean business. And I think it changes the practice for both landlords' attorneys, landlords, and also the judiciary.
Thank you. And thanks very much for testifying today.
Great. Thank you for the opportunity.
Good afternoon. Can you hear us okay?
Oh, yes, I can hear you now.
Okay, great. This is Adam Nielsen, who's a client of Empire Justice Center, and in front of us in person is Kristen Brown. Mr. Nielsen, the floor is yours.
What? Okay.
Go right ahead.
My name is Adam Nielsen. Thank you for allowing me to testify about my experience with Social Security overpayments. Since childhood, I received SSI disability benefits. I was born with cleft lip and palate with apraxia of speech that required many years of surgery and speech therapy. My advocates, Ms. Carr and Ms. LaRussa at Empire helped me with many SSI overpayments that happened since my childhood. The first time I was aware of them was 2013 when I turned 18 and SSA told me I was no longer eligible for SSI. I was told that I was responsible for about $60K worth of overpayments. I was not aware and had no control over my disability payments, with my mother used to cover living costs, including mortgage payments. My mother was unaware that when I was young, she needed to tell SSA about money from her car accident, and she didn't understand that it would result in an overpayment charge to me. Why was I responsible for the overpayments when I was a minor and had no control, and when SSI was only used to pay for our living costs? I learned about Empire Justice Center from my Access VR counselor and got their help in 2015. Having access to an attorney was important because all the complex law and paperwork dealing with SSI. But even with an attorney, the process was difficult. In the end, 7 to 10 years went by with multiple hearing hours on the phone with SSI and a letter to my senator to get things sorted out. The Empire Justice Center was able to resolve the situation and the overpayment from my childhood that were not in my control and not my fault. Ms. Carr explained to me that SSA was wrong about me being overpaid while 18 when I was still actually eligible for SSI through a special program because I was still in school at Monroe Community College and receiving vocational services at Access VR. It is frustrating that SSA did not inform me that I was eligible under those rules. My advocate at Empire not only helped me resolve the older overpayments, they made sure that I received the benefit that I was entitled to get after the age of 18. Because the burden of the overpayment and SSA's mistake about my ability for benefit, I lost trust in the system. I knew I may not be able to afford an apartment after college, and that would be getting in the way of my career goals. Thanks to the advocate at Empire not having the debt to SSA allowed me to pay back my loan from Monroe Community College, Clarkson, and University of Buffalo. I am currently at RIT and trying to get into a more in-demand field of semiconductor engineering without the help of advocate at Empire. The burden of that would have been crushing, and I would be stuck with fewer options and without the ability to navigate the complex rules for SSI. It's important to me that the resources are available to others who are trying to navigate the Social Security program like myself. I ask you to do everything you can to make that possible. Thank you for the opportunity to share my story.
Thank you very much for sharing with us. Do we have questions? Oh, thank you. Thank you very much.
Good afternoon. My name is Kristen Brown. I'm President and CEO of Empire Justice. I also serve as the president of the New York Legal Services Coalition Board of Directors, and that is the association representing the interests of civil legal services organizations and the communities that we serve. Thank you, Chief Judge Wilson, Chief Administrative Judge Zayas, distinguished members of the Court of Appeals, and State Bar President Kathleen Sweet. We are deeply grateful for the Office of Court Administration's ongoing commitment to civil legal services. The Judiciary Civil Legal Services funding is a crucial revenue source for Empire Justice Center and our peers. It's a key element in our ability to help our clients access justice. I also want to thank Mr. Nielsen for sharing his story with you today. As you heard, the rules guiding the SSI program are complex and difficult to navigate. Mistakes or confusion can have dire consequences. In his case, they put his economic stability and career at risk. By working with Empire Justice Center's Disability Advocacy Program, DAP, he was able to clear up debt that should not have been charged to him, and also access a little-known program that allowed him to continue his education. DAP serves approximately 4,000 low-income disabled New Yorkers seeking federal disability benefits statewide each year. By helping low-income disabled individuals navigate the complex Social Security system and access the much-needed and more generous federal disability benefits that they're entitled to, DAP increases financial stability and ultimately saves money for state and local governments. The services that we provide are all the more urgent right now because, as you've heard throughout the day, the federal government is cutting funding and changing the rules for programs, including SSI, programs which provide nourishment, healthcare, and more. The changes are making these complex systems nearly impossible to navigate. Funding cuts are impacting our client communities, our organizations, and our staff directly. Empire Justice has had contracts terminated, additional standards imposed, and our most vulnerable clients are actually being targeted. In this environment of chaos and threat, even more than during the pandemic, there is an urgent and increasing need for attorneys and legal information to help New Yorkers navigate this scary and ever-changing path. At the same time, the federal government is making it harder for nonprofits to provide services. That is why it's absolutely critical that OCA continues to build its investment in civil legal services this year. In addition to individual representation, I also want to highlight the importance of what we call state support, a role that Empire Justice plays in multiple substantive areas of law. State support includes coordinating and working with other advocates across the state to identify trends, issues, and systemic solutions, included needing training and legal resources. We play this role for DAP under a contract with the Office of Temporary Disability Assistance, providing legal technical assistance to DAP advocates statewide and training in the full range of SSI and SSD issues. The little-known type of SSI benefit known as Section 301, which Mr. Nielsen mentioned, was a topic for one of those trainings. Our statewide coordination ensures that the voices of advocates and clients across the state are unified and amplified, and it helps policymakers understand the real-world impacts of state and federal policy decisions. For example, last year, SSA acknowledged that cases exactly like Mr. Nielsen's, in which the person was a child when an overpayment occurred, are categorically eligible for a waiver of overpayment. This was one of several important rule simplifications and positive policy changes that came as a result of years of advocacy at the national level by DAP advocates. More recently, we have provided information about the impact of proposed changes at SSA and successfully pushed back on some of the more harmful proposals. We use our knowledge of the law in the most impactful way possible, whether it be to preserve and improve essential safety net programs like SSI, to train and connect DAP attorneys for maximum efficacy, or to provide legal assistance to individuals like Mr. Nielsen. At a time of unprecedented change and chaos, state support resources have never been more important for our clients, our peers, and policymakers. In closing, I'd like to highlight two requests. First, we ask that you provide at least an additional $25 million and a cost of living adjustment for JCLS to make progress towards the goal of $200 million annually. This will allow us to also continue to make progress in closing the justice gap. We also ask that you provide as much flexibility as possible to grantees so that organizations can respond quickly to the changes that are occurring at the federal level. During the pandemic, the term was pivot, right? We need to be able to pivot to respond to the quickly changing environment. Without that flexibility, the equity gains we've made will be reversed, and at the very same time as the demand for services is increasing. Given the threats to the rule of law and efforts to undermine institutions who stand up for low-income and marginalized communities, the work of civil legal services has never been more important, nor more under threat. To navigate the changes and assert rights, we need experienced staff who are able to focus on clients, strong and nimble organizations, and resilient structures to support our work, each other, and our clients. Thank you so much for your commitment to civil legal services, for your time and attention today, and I'm happy to answer any questions you may have.
Thank you. Questions?
So this morning, or earlier this afternoon, I guess it was, but earlier today we were hearing about community justice workers. And in your presentation, the training that you're doing for this DAP, would you say it's akin to community justice workers, or are you solely doing training for other legal professionals? That wasn't clear to me.
Oh, thank you for the question. So with the DAP program, we are providing training for both paralegals and attorneys. We're an accredited CLE provider, so we're providing CLE credits and training for attorneys, but also non-attorneys are able to participate in the trainings as well. We also run task force meetings where advocates come together and talk about what's happening in different regions, different communities, and so those include both attorneys and paralegal staff. In terms of the community justice worker model, that is something I'm actually very proud to be co-chair of the Permanent Commission working group that is exploring that with Janet Sable. We are very excited to be really researching and studying how New York can do something similar, and are planning to provide a recommendation to the Chief Judge on how we might be able to do that in the coming year.
Well, so the heart of my question was really, it seems to me that we might in fact already be doing some of it through, organizations like yours. We just haven't called it that, but we are already embarking on that path in that you are training paralegals or paraprofessionals, if you will, to be the ambassadors of and communicators or triage folk, if you will, for people's pressing legal needs.
Actually, DAP is a really good example of that because the the administrative hearings that folks are going to are because their administrative hearings, our paralegals are able to represent clients there. So that's one of the narrow areas where we are able to do that. And so it is a good example.
Thank you, Chief. Just a quick question. In just kind of referencing part of your remarks, you indicated that you have concerns about what certain federal cutbacks might mean to your organization and the limitations or the changes in the rules that may apply, and you need to pivot. Could you, if you can't, no problem, but could you give me an example of what you mean by that so I have a better understanding? In other words, what is it that you're maybe fearful of happening? And then how is it that we need to respond to that so that you have an ability to pivot? Do you follow my question?
I think so. So first, I'll give you an example. My organization is one of the organizations that is funded to provide representation to unaccompanied minors. And we had our contract terminated. Litigation was filed. The program is now running again, but we're on a every 3-month renewal basis. So we're able to continue to provide the services, which is fantastic. We were able to recall our staff who received a layoff notice because the contract was terminated. But we're on this 3-month renewal cycle. And when we thought that the contract was going away and we weren't going to have funding to provide the services, we were desperately trying to figure out, okay, how can, first of all, we have retainers with these children. They're our clients. Even if the funding goes away, we have an ethical obligation to continue to represent them. Second of all, this is critically important work, and we want to be able to continue to do it. How are we going to find approximately $600,000 to be able to continue to do the work? In a pivot, one way we could do that would have been to have other funds that we could use to do that work. For example, we could potentially use JCLS funding to continue to serve those clients and to do that work. And so that's sort of what I talk about when I say flexibility in how we use the resources.
So in other words, if the money's coming from the state, essentially, and it's earmarked for certain services, you want to have the ability to use them in a different way, maybe for administrative costs, maybe for payroll, to keep people that were working there working to satisfy their obligations to your clients.
Yes, and to pay salaries. I mean, one of the beautiful things about IOLA funding, you heard from Ms. Fecco earlier, is that it is incredibly flexible. And so because a lot of our contracts, we don't receive cost of living adjustments, we don't receive increases year over year, the DAP program is a very good example. We haven't had an increase in funding in the DAP program statewide in several years. And every year there isn't an increase, it's actually a cut, right? Because our cost of doing business and salaries go up. So we use our IOLA funds and, in some cases, JCLS funds to fill those gaps and to pay for things that other contracts won't pay for.
What does being on a 3-month renewal do to morale and retention of really capable lawyers and staff that are working for you?
It's very difficult. I mean, our attorneys that are on that, and paralegals that are on that, actually our attorneys that are on that contract, are already dealing with some of the most challenging issues that are happening in our country right now. You hear about kids going into court, 2 years old, they don't speak English, and they're supposed to represent themselves. Our attorneys are the ones that are representing those kids. That is incredibly challenging work, but also incredibly meaningful. To be on this sort of insecure funding stream is incredibly destabilizing. But I have to say, just a shout out to our wonderful staff. They're so committed to the work. They're still with us. And we are the Empire Justice Center, we're doing everything we can to try to make sure that we're able to continue to do the work. Hopefully it will stabilize eventually. But yeah, it's very hard on morale, as is everything that's happening right now. That's just one example, but the concern and the issues that are occurring in our client communities right now are horrific, and of course are having an impact on the attorneys and staff that are working with.
Thank you for your answer.
Thank you.
And thank you very much for your testimony. Okay, next we're going to hear from Matthew Adinolfi and Adrian Holder.
Okay, thank you, Your Honor.
Thank you for being here.
Distinguished panel. My name is Matthew Adinolfi. I live in Essex County, New York. In 2018, I read an article about a man in New York City who had a lot of medical problems that were made worse because he did not have teeth and Medicaid would not cover the kind of dental care he needed. He was part of a lawsuit that was trying to change the Medicaid rules. I saw that article and reached out to the Legal Aid Society to thank them for what they were doing because I had been struggling for a long time because of my inability to get the dental care I needed. I also wanted the lawyers to understand that not getting dental care has a serious impact on people's emotional and mental health. Many years before, I had teeth pulled because Medicaid did not cover root canals and I could not afford to pay out of pocket for them. That caused my surrounding teeth to come loose and have problems. Then in 2010, I got an infection that required me to have most of my remaining teeth pulled. I was given upper and lower dentures, but the dentures never fit me. They slipped out of my mouth, and I was not able to chew with them. A few years later, I paid out of pocket for a permanent bridge spanning my front and lower teeth. This permanent bridge did not include back teeth because I could not afford it. For over 10 years, I didn't have the back teeth I needed to chew my food. I didn't wear my upper dentures because they rubbed up against my gums and palate, causing irritation, bleeding, and pain. My dental problems also caused me social and emotional problems. Over the years, I became more and more isolated and depressed because of my lack of teeth. When I would go out to eat with people, I would make excuses and tell people that I had already ate. When I would meet someone I was interested in romantically, I wouldn't pursue the relationship. The situation with my teeth always kept me in the dark. This was my situation for nearly 15 years. I ended up joining a lawsuit. Legal Aid worked hard to get me the dental care I needed. When I couldn't find a dentist in my area, Legal Aid helped me search for a dentist. I ultimately found a provider who would work with me, but he did not take Medicaid. Legal Aid worked for me to see that dentist, worked with me to see that dentist who also donated some of his services that he felt I needed that Medicaid would not pay for. When the dentist needed to get paid up front and Medicaid would not do that, Legal Aid found a charitable donor who provided a loan, so I did not have to take out a credit card or borrow money. Legal Aid worked out an agreement so the dentist could get paid up front and I could get the work started as soon as possible. This became especially important because I had developed a serious infection that needed immediate treatment. Legal Aid provides essential services and advocacy for New Yorkers. I've been told that so much of what Legal Aid does would not be possible without the consistent investment of the judiciary civil legal services funded since 2011. Getting this dental care has changed my life. I now have a full set of teeth that I have never had before. I'm a lot happier. My mouth is functioning, and I can eat different kinds of foods now. I am more social, and I've learned to smile again. I also want to thank Belkey Garcia from Legal Aid, who I can't thank enough for the work that she's done with me and for all the other people that she's helped to get this case won. And I also want to thank Dr. Kurt Klein, who took the time to work with Belkey's and donated more than, he gave me, Medicaid only wanted to do so much, and he thought that I needed to have more done, and out of his own pocket, he did that for me. So I just want to thank everybody, Legal Aid, and thank you for having me.
Thank you for sharing with us. I'm sure it was a little bit difficult, but it's wonderful to see you. It's wonderful that you're smiling again.
I'm trying.
No, you
I
are.
have to work on my smile muscles.
No, you're doing a pretty good job, I would say, and speaking really well. And I had only really an observation, which is that, we've heard a lot of pretty depressing things over the course of the day. We're in a very difficult time. But, your story should remind us that there are good people out there, like Dr. Klein, like the charitable donor, like the people at Legal Aid who are thinking creatively out of the box to find a solution for you. And it's difficult times, but there are good people, like yourself.
Thank you.
There was some quizzical questions around here about why you weren't closing us out today, as you usually do, but we'll take you in whatever order you're here.
I like being the closer, but that's okay.
Next year.
Yes, it is always next year.
Welcome back.
Thank you. So good afternoon. I'm Adrienne Holder. I serve as the Chief Attorney of the Civil Practice of the Legal Aid Society, and I'm honored to serve as a member of the Permanent Commission on Access to Justice and as a board member of the New York Legal Services Coalition. At the outset, I would like to extend my deepest thanks to the Chief Judge Wilson, presiding Justices Renwick, LaSalle, Gary, Whalen, Chief Administrative Judge Judge Zayas, and of course, State Bar President Kathleen Sweet, for the opportunity to address you all today. Investing in civil legal services is not only an investment in access to justice, but it's also a long-term commitment to combating racism, poverty, and inequality. With the support of JCLS, funding providers like the Legal Aid Society, we are able to deliver both direct legal representation to individuals in crisis and systemic advocacy that addresses the root causes and removes barriers for entire communities. In this way, legal services not only helps those who walk through our doors, but also creates lasting change so that many others will never need to seek legal help in the first place. On behalf of the Legal Aid Society and the broader New York State civil legal services community, I extend our sincere gratitude for your continued investment and support. One of the examples of this dual impact is in the area of access to dental care, as you just heard. Adequate dental care is crucial to overall health and well-being. Poor oral health is connected to cardiovascular disease, respiratory infection, adverse pregnancy outcomes, and chronic conditions such as diabetes. It can also have a profound impact on mental health and employability. Low-income New Yorkers, immigrants, and communities of color are far more likely to experience poor oral health. New York's Medicaid program has long included a dental benefit, but until recently, some of its clinical rules had not been updated since the 1960s. For decades, coverage excluded molar root canals and crowns, required people to lose half their teeth before becoming eligible for dentures, and denied replacement dentures more than once every 8 years. Critically, dental implants were entirely excluded, even when medically necessary, forcing many people to go without teeth or incur crushing medical debt. In 2018, the Legal Aid Society, through our law reform unit, and Belkey Garcia, who is here with me today, one of my favorite star attorneys. I have so many of them, too. And pro bono partners brought litigation to change these outdated rules. After years of litigation through the COVID-19 pandemic, a settlement was reached in 2023, and new rules went into effect in 2024. These reforms lifted the ban on dental implants extended coverage to molar, root canals, crowns, and replacement dentures, and impacted more than 5 million adults enrolled in Medicaid in New York. The effect has been life-changing. Our health law practice has already assisted more than 200 people individually in overturning Medicaid denials, restoring their ability to eat, work, and live free of pain. At the same time, our work is now challenged by federal threats. H.R. 1, signed into law earlier this summer, makes the largest cuts in Medicaid in the program's history, an estimated $1 trillion over 10 years, with up to 1.5 million New Yorkers projected to lose coverage. Work requirements, shortened renewal cycles, and increased administrative burdens will create barriers to care, especially for vulnerable populations, including immigrants. The cuts will put enormous strain on the healthcare system, and civil legal services will become even more essential in helping people navigate these shifting and punitive rules. These proposed cuts will also disproportionately harm communities already marginalized within the healthcare and legal systems. Immigrants will face new eligibility restrictions and procedural hurdles. Seniors living on fixed incomes will struggle to maintain coverage under burdensome re-enrollment requirements, and transgender and gender nonconforming New Yorkers who already experience high barriers to care will face renewed threats to the gender-affirming services they depend on. The Legal Aid Society has always risen to meet these challenges, as we did in Cruz v. Zucker, where we successfully fought for Medicaid coverage of gender-affirming health care. We will continue to respond as client needs evolve, but without adequate resources, the ability of our staff to provide both direct representation and systemic advocacy will be severely constrained. Beyond the direct cuts, H.R. 1 also threatens to weaponize federal power in ways that could undermine the very legal and advocacy work essential to protecting vulnerable communities and the work of our partner organizations that provide the holistic services our clients rely upon. This creates a chilling effect that risks silencing advocacy at the very moment when those communities need it most. Despite these challenges, the Legal Aid Society and our partners remain committed to ensuring equal justice for all New Yorkers, but we cannot do it without stable and sustainable investment. As a board member of the New York Legal Services Coalition, I want to underscore a simple truth. The progress I've described today and that you've heard throughout this afternoon, whether in the courtroom or on behalf of individual clients or in the systemic reforms that benefit millions, depends on your continued commitment to funding civil legal services. That means holding the line on current funding levels without reductions, ensuring annual cost of living adjustments, and preserving flexibility so that the providers can meet evolving needs, address pay parity, and sustain the infrastructure. Just as importantly, we must continue to move towards the long-term goal of $200 million annually. This begins with an increase of at least $20 million this year, paired with a COLA. Without this additional investment, programs and staff will be destabilized at precisely the moment when demand for services is increasing. In short, we must keep our eyes on the prize, building a legal services system that is strong, equitable, and durable enough to weather federal cuts and meet the surging demand ahead. With your continued leadership, we can sustain the life-changing work already underway and ensure that the promise of justice is not reserved for the few, but realized for all New Yorkers. So again, on behalf of the Legal Aid Society, thank you for your continued support, and thank you again for the opportunity to testify before you today.
Thank you very much. Questions?
Just,
I'm sorry.
Chief Attorney Holder, you are not the last speaker, but always tremendously impactful and always stretching, at least my understanding and awareness of the great breadth of the work of the Legal Aid Society here, assisting someone with dental work. And I thank you and the attorneys who you mentor for their great work.
I really appreciate that. Thank you so much, Presiding Judge Renwick. Again, I have a star attorney in the back, and she represents so much of the real talent and the dedication of our staff and the creativity, the ability to think out the box and to come up with solutions. We always say that we never and I think in our entire community, we never let a crisis go to waste, and COVID definitely stretched us, and I'm so glad that we were able not only to bring this case in 18, but settle it during COVID. I was very eager, and I think asked them weekly where we were with the settlement on this case, and so many other things that this entire community does. It's the best legal services community in the state, and I'm proud that the Legal Aid Society is a part of it.
And we certainly need to remain ever creative now.
Yes, yes,
Thank you.
and we are, we're ready, we're ready.
If I may, I just wanted to also just add my voice, and Ms. Holder, you've been doing this work for so long, you do such an outstanding job, and I just also want to commend the Chief Judge for his advocacy to bring in additional, 40%, Judge, did you bring in this year? I mean, that's an incredible amount of money that he's brought in, and with the help, of course, the governor and the legislature. But I think the biggest thing about today's hearing and hearing from your client and other clients today is really bringing to light issues that, quite candidly, at least I can't speak for my colleagues, but I'm not thinking about on a daily basis. And to think about the lives that you're affecting, they seem, to others it may seem like they're small, but you're changing someone's life. And it's so incredibly important, and the money that's been allocated, it's always, I know it's a drop in the bucket to what you all need, but I think every dollar helps, and every step that we can work collectively to assure that the indigent and the working poor in this state have access to excellent legal help is important. So I want to commend you, and again, everyone else, again, really the Chief Judge of the State of New York for his commitment to this cause. So thank
Yes,
you.
there's tremendous leadership that's sitting before me, and I really do appreciate everything that you all do and the investment that you made. Thank you for your comments, Presiding Judge LaSalle. I would like to say the investment, although you said, and I appreciate you saying a drop in the bucket, we still know it's significant because you all have a lot of competing demands. But for the state, and we hope that the governor and other leaders in the state realize what a tremendous investment it is that ultimately saves government money. And so, that is the real practical, operational, and to me, fiscal interests that government should have in that. And then in terms of the real life, consequences, I met up with a client who testified earlier and how inspired her story is, lieutenant now, how in less than one generation people can completely transform their lives. But what we see is that we're just the instruments for that. What I get from doing this work and working alongside my legal services community is the restoration of faith and inspiration I have in the human spirit. Our clients are amazing, and all they need are for people like us to kick down the barriers that they are facing, and then they do everything else on their own. And thank you to our client, Mr. Adinolfi, as well as all the others who've testified today that continue to inspire us in that way.
I do just want to add an exclamation point to a sentence or idea that you ended with a period, and I'm not blaming you for soft selling it, but the legal service providers in the state do a terrific job with way too far resources. And the most important thing that I think we can try to do over the next couple of years is to bring you to pay parity with governmental lawyers who are essentially doing the same kinds of things you're doing. Because you can't keep, train, and retain the quality of people you have. They can't have normal lives. They can't live in a decent place or have the things that somebody with their talents should be able to have. I realize how committed they are, but they shouldn't have to pay for their commitment.
I appreciate that, and we agree.
Chief, can I just ask, so obviously, thank you so much for all that you do and your team in the back that you keep making reference to. Your written testimony says you were requesting for $25 million this year paired with a COLA. But in your old testimony, you said 20 million, but that was a slip of the tongue?
Yes, that was a typo.
25 million, because I think it's being recorded. I just want to make sure that was.
Thank you, I appreciate that, and I did not catch that, but yes,
25
25
million.
million, yes.
Okay, thank you.
Thank you.
Thank you.
We are next, I thought, going to hear from Marisol Estrada Cruz, but also Sal Curran.
Thank you so much, Your Honors. I want to say you're going from one of the largest legal aid providers in the state to now one of the smallest legal aid providers in the state, which I think really echoes how important the JCLS funding is at every level of the provision in the state and in every geographic region of the state. So my name is Sal Curran. I'm the executive director of the Volunteer Lawyers Project of Central New York. I'm also a member of the Permanent Commission on Access to Justice and a board member of the New York Legal Services Coalition. I really do want to thank you, Judge Wilson, Judge Zayas, Judges Gary, Renwick, LaSalle, Whalen. This is such an honor to be able to be here before you today, and it's such a pleasure to be here in person. We are going to be doing something a little bit untraditional. I'm going to give half of my comments, and then I'm going to stop, and my colleague is going to give the comments of our client on our client's behalf, and then I will wrap up my comments. So thank you for bearing with us. I also want to say it is very unfair to put somebody after Adrian Holder, my most impressive colleague who I have the utmost respect for, and it's truly unfair. But as always, it's an honor to go after you. So Volunteer Lawyers Project of Central New York, our mission is to provide access to justice by engaging the legal community in service to those in need. And so while our staff is small but mighty, 30 people, we engage over 600 volunteers a year, lawyers, paralegals, law students, undergrads even, in providing free legal assistance to those in need. And last year, we assisted over 4,000 people with that. I first wish to speak to funding challenges. We are seeing growing challenges in maintaining services in the face of a very uncertain federal landscape. This year, we started the year losing about $400,000 of promised federal funding, which was nearly 10% of our budget. Without the increases from IOLA and JCLS, we would have been forced to lay off staff and reduce services pretty substantially. I will say to preserve this impact of JCLS, we really do need maximum flexibility in the funding. And I do want to echo as well the idea of community needs shifting very quickly. For example, requests for debt assistance in just the last 3 months has risen 30% for us. And I do want to just say that as Judge Wilson indicated, the increased funding is needed to close that gap. And I also want to echo Kristen Brown and Adrian Holder's request for the $25 million increase this year. I know it's a lot, especially coming after such a huge increase last year, but we really are committed to continuing to close that justice gap. Federal changes also threaten recruitment and retention. The public service loan forgiveness has been vital to attracting young attorneys to work in under-resourced legal aid organizations. New restrictions may and almost certainly will exclude organizations like ours who serve immigrants and transgender minors, because we will not sway in our values to serve the community in need. Already, one young attorney that was working with us left us for a state job, citing uncertainty over PSLF for her loans, and also she received a 60% pay increase. So to compete, we do need that flexibility in funding and to raise our wages to maintain our staff. So thank you for your comments on pay parity. I wanted to stand up and start cheering when you said that, but decorum. Our work with immigrants really highlights the incredible risk and the incredible stakes of legal aid work right now. We had hoped to bring a client to testify, but as we prepared for the hearing, we realized that there was not a single immigrant client that we have served in recent years that we felt safe having openly testify here in court. We were very concerned that even giving their first name or having their face appear on a screen could result in them being put in detention and removal proceedings. So with that said, and because we believe it's so important for the panel to hear the voices of immigrants who do not yet have citizenship, one of our staff attorneys will read the remarks of our immigrant youth client that he would have given on his own if he felt safe to do so. So I'm now going to hand off our testimony to Marisol Estrada Cruz, the supervising attorney of our pro bono immigration program, who together with a pro bono attorney represented this client. And then I'll finish my remarks when she's done.
Okay, good afternoon. My name is Marisol Estrada Cruz. I'm an immigration attorney at Volunteer Lawyers Project. The testimony I'm about to read is from one of our clients who's an immigrant youth, wishes to remain unidentified, but has given consent for us to share his testimony. So I grew up in Ecuador with both of my parents until 2015, when my mother fled and took me with her because my father's abuse had become unbearable. He beat her so badly her body was covered in bruises. After some time, I told my mother I wanted to live with my father again because I missed him. At first, things seemed fine, but by 2017, he began drinking heavily and turned his anger on me. He beat me, forced me to leave school, and made me work to pay his debts. As a child, I did grueling and dangerous labor, caring for livestock, working construction, and using heavy tools and machetes. My father took all of my money that I earned and gave me almost nothing. I often went hungry, surviving only because neighbors shared food. If I resisted, he beat me until I was bruised or bleeding. By 2021, his violence escalated. Every night, he came home drunk, screaming and hitting me, blaming me for all his problems, and cutting me off from my mother. I felt hopeless and trapped, thinking I would be better off dead. In 2023, I finally reconnected with my mom and told her everything. She explained that she had fled to the US after my father tried to kill her. A supervisor at work helped me find a way to reunite with her. If I am forced to return to Ecuador, I know I will face the same beatings, the forced labor, and the isolation. I will have no protection and no future. When I arrived to the United States, I reunited with my mother and searched for an attorney to help with my immigration process. For months, we found no one, until February 2024, when the Volunteer Lawyers Project of Central New York connected me with a pro bono attorney. The attorney explained the guardianship process and what it meant for my family. My mom was afraid to go to family court because of her lack of immigration status. But the attorney assured her that the only concern the family court had was whether she was willing and able to care for me and whether it was in my best interest to have her appointed as my guardian. With that reassurance, she found the courage to move forward. My mom was appointed as my guardian. Shortly after, my special immigrant juvenile visa status application was submitted and quickly approved. I was granted deferred action and a work permit. My immigration removal case was dismissed, and for the first time in years, I felt safe. I am deeply grateful to Volunteer Lawyers Project and the attorneys who stood by me. They gave me stability and hope. While I know I must wait years for a green card, I remind myself that here I am safe, and I finally have a chance to build a better future.
Thank you so much, Marisol. So our client gained lawful status and stability only because of VLP's free legal services. He never would have known about special immigrant juvenile status, nor would he have been able to navigate family court and the immigration court on his own. He also would not have felt safe to appear in family court or go through the guardianship process if there was a risk that ICE could have picked him up in the courtroom. Yet today, immigrant youth face unprecedented threats. The federal government has cut funding for immigration services. It's attacked law firms providing pro bono immigration services, rescinded protections like deferred action and work authorization, which is why he cannot appear today, and challenged New York's safeguards that keep ICE out of state courts without a judicial warrant. Families are losing food, medical, and case management support just as legal aid is being stripped away. This makes the role of New York state courts more critical than ever. Youth abandoned, abused, or neglected by parents can only apply for special immigrant juvenile status if the state courts make a required finding. Survivors of domestic violence may only feel safe seeking protection in state court, and only once they get those orders that open doors to immigration relief can they then apply for relief under VAWA. Crime victims may only access U visas if state judges or state officials provide certifications. State courts, to be clear, do not grant immigration status, but they provide the essential foundation for these processes to even begin. Without access to court and legal services, immigrant youth, survivors, and other vulnerable New Yorkers will be left unprotected. So with the stakes in 2025 higher than ever before, flexible state funding, strong support for legal services, and continued commitment to protecting the role of our courts are essential to ensuring equal access to justice. I want to thank you for your past and future support, not only of my organization, small but mighty as we are, but also for all of our colleagues across the state. I really echo Attorney Holder's statements. This is an amazing legal aid community, and we are honored to be funded by the courts, and we thank you for your continued support.
Questions? I have one for you. You use a lot of volunteer lawyers, and have you found that currently there's more reluctance to help, or
No.
that hasn't really affected people?
It has not. In fact, we've been getting more inquiries than ever before. But I think part of that is because we have smaller law firms in our region. We've also seen a tremendous surge of interest in retired attorneys. Yeah. Mm-hmm.
We have an attorney emeritus program.
Yes.
And if there are things that through that we can do to help you even further. I mean, it's nice to hear that pro bono lawyers are not deterred, and in fact maybe are encouraged to help more and recognize the need that now exists in greater measure than before. So.
Yeah, we actively engage in the Attorney Emeritus program. I think it's an amazing program that needs to be lifted up more. So few people take advantage of it compared to the number of folks that are retiring and the rate in which they're retiring at this point. I want to just say how impressed I am with the commitment of the courts and the Attorney Emeritus program to continue a focus on the importance of equity and inclusion in the face of federal pressures. So thank you very much for that decision and that work. And I also want to say that, I know that we are fortunate to continue to have attorneys stepping forward in Central New York. I know that attorneys across the state want to continue to step forward, but because of pressures are not necessarily able to. And it is, I just want to say how incredibly important it is for those who are able to continue to step forward, because they make such a difference. I know you didn't ask about this, but I'm going to go ahead and say, because I know a big comment has been about the community justice workers as well. And I want to say that we've had so many paraprofessionals and law students and those interested in the community stepping forward to help and volunteer in so many different capacities right now as well. And so I'm very excited to see what will come out of the recommendations of the subcommittee that I also serve on.
So you did actually mention undergraduates as well.
That's correct.
And I was a little curious about how you're able to employ the undergraduates, but which you can address if you'd like, but the thing you just said recently, just a second ago, made me think about P.J. Gary's rural justice programs, and that she's working on building a pipeline so there are lawyers there, but it seems to me that there may be some ability to interact there and even get people who are undergraduates into a pipeline earlier.
Yes, Judge Gary, I have been meaning to reach out to you for some time because everybody keeps singing the praises of that rural justice pipeline. My organization has made it one of our strategic priorities to increase the pipelines into the legal profession, especially for the community that's directly affected. And we're currently piloting a program where we are bringing folks who are interested in becoming paraprofessionals in and trying to work them through sort of a onboarding and sort of similar to the paid internships that we do for law students, do that for paraprofessionals. So I'm very excited. We also do it for law students. We have our Access to Justice fellowships that have been central to our equity work, and I'm excited about talking about ways that we can continue to expand that work throughout the legal services community, because we absolutely need to continue to grow our community.
If I may, thank you. I look forward to hearing from you and working with you. And I'm very glad, first, that the Attorney Emeritus program came up, because my colleague Christine Clark has been, I know that she's been really engaged and working hard to revitalize that throughout our state. This has been an illuminating day in so many ways, as it often is. Because this community justice workers is intriguing to me in a way that initially my concern, my pipelines, I'm trying to build lawyers,
Absolutely.
And it's also the most direct path in my view, because they're ready to, they're on the cusp of being, fully ready to serve. But my eyes are being opened to the potential. I had been concerned about a perception, particularly as regards the rural communities, about two tiers of justice. And so my focus had been on lawyers, but I'll share that there may be room for further expansion. As you've just had that discussion, and as I've been hearing this afternoon.
Yeah, I definitely think that this is a yes and proposition. I think of how when my hometown in Maine, a very small town, decided they wanted to have a football team, they started with a peewee football team. And then every year they added another year to it until they had a high school team. Long after I was gone. I didn't get to play in marching band, tragically. But it's similar to that. That's our approach, is that we bring in the undergrads or people who maybe never even went to college and have an interest in serving in a legal aid community, so that they can really get invested in the work. And I can't tell you the number of undergrads that we've had come through over the years who say at the end of it, I've decided I definitely want to go to law school now. And some of these folks are folks that they'll be the first generation that of their family going to law school. They're the first generation that went to undergrad. And so I do think that this is a long vision of a pipeline. And certainly in your district, we do serve up in your region in many different areas, both immigration, more recently in eviction and whatnot. Our LGBT rights program is up there. And so we're very acutely aware of the lack of attorneys. So I don't want to say stop focusing on attorneys. I'm saying it's a yes and it's the way to build up a larger bench.
To be clear, the rural initiatives we're undertaking are truly statewide in scope. And I've been working with Scott Del Conte in the 4th department. So it's not limited, but I mentioned his name. He's specifically in the 5th JD. But probably we should stop chatting.
Although
clearly,
Counsel,
we could chat longer.
I do want to just say one thing. I'm glad to hear you say that we do reach out to help the 3rd department. It'll give me a little bit of.
That's right. Exactly. We don't forget you. Yes, don't give me a mic. I'll walk away now, finally. Thank you so much.
Thank you. Next is Eve Stotland, the Program Director for New York Community Trust. Welcome. Thank you for being here.
Thank you so much, and good afternoon, Your Honors. My name is Eve Stotland, and I'm the Program Director for Human Justice and Civic Affairs at the New York Community Trust. Thank you for holding this hearing to discuss the barriers to justice for low-income New Yorkers and other vulnerable communities. The New York Community Trust stands with the judiciary's support of civil legal services as a bedrock of access to justice and the rule of law. I have spent my career as a legal services lawyer devoted to nonprofits and to using the rule of law to defend my clients' rights. Indeed, I worked for 2 nonprofits that received JCLS funding before moving to philanthropy. Now, as a program director at the Trust, my mandate is to advance the tremendous network, this network we've been discussing and hearing from today and celebrating, of legal services providers that brings value to every New Yorker. For 100 years, the Trust has helped generous New Yorkers come together to support the causes they care about and create thriving, equitable communities. In 2024, the Trust made more than $60 million in competitive grants to nonprofits in New York City, Westchester, Suffolk, and Nassau counties. We are a long-term supporter of civil legal services, court innovation, and access to justice for pro se litigants. Civil legal aid plays a valuable role in helping New Yorkers thrive. It keeps people in their homes, makes sure that children get to school, and ensures that people with disabilities have equal access to public accommodations. It defends immigrants who face wrongful deportation and keeps families of color together when racial biases increase their risk of separation. Philanthropy does not have the resources to replace the judiciary's civil legal services program, let alone the safety net programs affected by H.R. 1, SNAP, Medicaid, housing vouchers, and others. Instead, philanthropic institutions deploy our limited resources to improve and expand upon existing civil legal aid programs. For example, the Trust made a grant to New York Legal Assistance Group to help New York City's nonprofits stay up to date on fast-moving changes in immigration law. With another grant from the Trust, New York Law School trained a new cadre of supervising attorneys to oversee a major expansion in tenant representation in New York City. Philanthropy can also encourage government to expand legal aid for new populations or problems. In 1987, the Trust helped found the New York Immigration Coalition, which has played a major role in expanding immigration legal services across the state. The Trust grantees, including the Right to Counsel NYC Coalition and the Housing Justice for All campaign, have successfully expanded tenant protections, including access to counsel in eviction proceedings. Philanthropy supports the development of new ways to deliver services. Our grant to Pro Bono Net helped create Reclamo, an app that allows construction workers to determine whether they've been victims of wage theft. With our support, a group called Family Legal Care created tools that allow family court litigants to fill out petitions without the expensive Adobe software used by the Office of Court Administration's online forms. And Just Fix, another grantee, developed a digital tool for identifying and tracking buildings with poor housing conditions. These philanthropic investments augment and improve the direct services provided through OCA's JCLS program. The coming years will bring drastic cuts to healthcare, food assistance, and other safety net programs. They will also bring increased enforcement against immigrant New Yorkers and people without homes. Looking forward, government resources for civil legal aid will remain crucial. Thanks to the legal providers, many of whom are here today, New Yorkers will keep their Medicaid despite new and burdensome work and recertification requirements. Thanks to these providers, transgender people will have birth certificates with the correct names and sex. And with legal services warriors on our side, immigrant New Yorkers will have a shot at due process when they are detained. Philanthropy stands ready to help civil legal aid providers work more efficiently and effectively. But our effectiveness is tied to theirs. If government support for civil legal aid diminishes, the value of our support does too. In the worst case scenario, we as funders scramble to replace government cuts and lose the ability to support innovation, retention of staff, and other things that are very important to our grantees. This is true across all sectors, not just legal services. Philanthropy can only be its best if government finds a way to maintain the programs that allow New Yorkers to thrive. The New York Community Trust is proud of our partnership with legal aid providers and with the courts. We ask that you reach out to us anytime we can be of assistance in promoting access to justice. Thank you.
Thank you. Questions? Thank you very much.
Thank you.
Closing us out today is Neil Steinkamp.
Chief Judge Wilson, distinguished panelists, it's an honor for me to have the opportunity to provide this report for your consideration. My name is Neil Steinkamp. I'm a managing director at Stout, where I lead the firm's transformative change practice. I also lead the firm's pro bono practice and serve as a consultant to the New York Permanent Commission on Access to Justice. I offer this report today regarding the impact of potential funding cuts, as you've heard about, to civil legal services, as well as the valuable economic contribution of current civil legal aid funding, which we've also had a chance to hear a little bit about today as well. As you heard from Christine Fecco earlier today, the legal services sector in New York serves over 1.1 million New Yorkers annually, closes over 330,000 cases, employs 5,700 people, and coordinates more than 40,000 pro bono volunteers across every county in the state. These organizations, New York Civil Legal Services organizations, are, as we've heard, facing significant costs, putting, as Christine mentioned, $80 million at significant risk. This could mean 90,000 fewer New Yorkers receiving legal assistance, including more than 16,000 children. New Yorkers with household incomes below 200% of the federal poverty level, facing complex civil legal problems that can lead to homelessness, child trauma, deepening poverty. This funding challenge occurs against a backdrop of worsening poverty across New York State. 13.9% of New York State residents are currently living in poverty, higher than the 12.8% nationally. In New York City specifically, 25% of residents are living below the poverty line, nearly double the national rate. Over 2 million New Yorkers, including 420,000 children, now live in poverty. The child poverty statistics are particularly concerning. New York State's child poverty rate of 18.8% ranks us 41st in the nation, one of the worst. In New York City, the child poverty rates reached 26%, the highest observed since tracking began. While pandemic-era federal supports temporarily reduced child poverty, those rates have increased significantly, doubling in 2022 and surpassing pre-pandemic levels. And as we know and as we've heard today, most New Yorkers facing civil legal problems do so without being able to access effective assistance necessary to help them. Despite these challenges, I think it's very important to note that the civil legal services community is demonstrating remarkable resilience through innovation, in addition to the many ways you've heard about them responding to these crises today. A few examples include Westchester County launching its Office of Housing Counsel with comprehensive access to counsel. Legal Services NYC won the inaugural Lex Prize for developing an award-winning knowledge management portal. In addition to the Justice Infrastructure Project that Christine spoke about earlier, IOLA's advanced strategic initiatives around artificial intelligence, including AI University, workshops to equip organizations with essential skills for the responsible use of artificial intelligence. Additionally, as Nicole Nelson mentioned earlier today as well, and we've had some great discussion about, 9 states have implemented authorized justice practitioner programs to leverage the ability of supervised, trained non-lawyers to effectively assist people with civil legal problems. And 20 other states are considering similar approaches to help close the justice gaps in their states, a strategy the Permanent Commission, as you've heard, has also been exploring this year. The return on investment for civil legal services, as was noted earlier several times today, is both compelling and well documented. more than 50 independent studies conducted over the last 25 years have found that every dollar invested in civil legal aid generates an average return of between $5 and $10. And this is occurring through two primary mechanisms. So the first of those is that legal intervention prevents cascading problems that require extensive public interventions. In New York City, for example, eviction cases, tenants representing themselves are evicted in nearly 50% of the cases. When represented, they maintain their housing in 90% of the cases. In work that we have done across the country, between 15 and 30% of clients who seek legal assistance in eviction cases indicate that they would experience homelessness if they were forced to move. More than ever, we have data on these strategies and interventions to help us understand both the impact of the services being provided and the consequences that people are very seriously facing in these cases. 45 to 61% of the people reaching out for assistance in their eviction cases have no plan for where they would go and would also likely be facing homelessness. We've also heard today about the impacts of oral health, of SSI benefits, of domestic violence, and others. In each of these examples, you can see how the downstream effects, if legal services had not been provided, would have been catastrophic, would have been devastating, had already been, and would certainly lead to significant needs for public interventions to help individuals and families in circumstances that we were able to avoid. Second, strategic investment and implementation can reduce the number of cases filed. We often talk about the return on investment in the ways that I just did, the ways in which it avoids these downstream effects. But investments in civil legal aid also change the system, right? They change how the actors in the systems behave. And so these investments also have the ability to reduce the number of filings. That prevents both those issues from occurring in the first place and obviously all of the related downstream effects. We've observed this in New York. We've observed it in the work that we've done in Cleveland, in Delaware, in Connecticut, and Milwaukee. When implemented strategically, civil legal aid changes the justice system in profound ways. The cost of inaction is substantial and measurable. Without legal representation, problems cascade across multiple systems. One additional eviction per 100 renter households increases child abuse reports by 1.3%, increases foster care entry by 1.6%. People experiencing homelessness use emergency departments far more frequently than housed people, with costs approximately $1,000 higher per discharge. Students experiencing homelessness score at the 12th percentile on standardized tests compared to the 75th percentile for students who are stably housed. People experiencing homelessness face mortality rates 10 times higher than the general population. These effects are very real, but not just the effect in the crisis, right? It's that connection to the ways in which government responds to those that causes these fiscal investments. As we consider incremental additional investment in civil legal services, as we know, the justice gap is still not a gap. It's still a chasm, as Judge Heck mentioned earlier. Additional investment is needed. An iterative implementation with comprehensive data collection for this funding enables systemic observation of how additional capacity affects service delivery and demand, tracks whether increased services are leading to reduced case filings, supports data-driven learning about intervention effectiveness. With the rapid advancement of technology, the development of new forms of intervention, changing social systems, and innovation in the delivery of civil legal services, an incremental investment in civil legal aid combined with comprehensive data strategies can ensure that we're able to work collaboratively to maximize the impact of that investment and create new pathways to close the justice gap. In a time of unprecedented change, as we are in today, it's often prudent to think about those incremental steps. In this moment, an incremental step of, as we've heard about, $25 million additional investment enables us to respond to the risks that we're looking at in terms of funding reductions while also amplifying the impact of technology, amplifying the impact of collaboration, amplifying the impact of innovation, and as Eve just mentioned, amplifying the impact of philanthropy as well. In conclusion, the current federal funding changes present both significant challenges and opportunities for New York State. Strategic incremental increases in state funding combined with technology investments, enhanced coordination, collaborations across this amazing community can build a more resilient system serving all New Yorkers. The evidence clearly demonstrates that the investment in civil legal services generates substantial returns through prevention of more costly interventions, economic stability, and the reduction of long-term societal costs. Through a data-driven implementation and sustained commitments to increased funding, New York can develop civil legal services infrastructure that effectively serves current needs while building capacity for future challenges and opportunities. Thank you.
Thank you. Questions? Anyone? Nope. I have one for you. And I was talking with Chief Justice Hecht a little about this last night. So, as you said, I think there's very good data that if you spend money now, you save much more money. The problem is you save it later, and you save it in very diffuse ways. And it then seems to me a hard sell, or at least it's a difficult proposition to explain to people that if they spend the money now, it's going to redound to their benefit in ways that they can't see 10 years from now or 20 years from now. How do we better go about that?
Well, I think it's a great question, and it's one that I encounter in a lot of jurisdictions that we work in around the country. And there's many elements to that question. Two that often come up are both the sort of delayed gratification element of it, as you know, that the return doesn't happen immediately. It's not perceived to happen immediately. I would say it's also can sometimes be difficult to quantify exactly and precisely. People's lives are changing, as you've heard today.
Right.
Real lives are changing. It's hard to quantify the ways in which there's value that contributes there. And even when there are ways to quantify it or identify it precisely, it's hard to put a dollar amount on it. We know that there are changes in trajectories and opportunities, but what did that mean? How did it directly connect to the provision of the legal services and not the many other things going on in people's lives? And third, the benefits often accrue across state government, county government, local government. And so oftentimes people will say, well, it's a benefit, but it's not my benefit. So, you'll want to talk to someone else about that funding. I think for me, the important sort of consideration that we try to offer is it's a we conversation that the benefits are clear. And while they are delayed, if we don't make the investment now, we're not going to recognize the benefits later. In addition, as you start to make the investments, you're going to learn things along the way. Some things do respond very quickly. Actors in these spaces, particularly in a capital economy like we have here, will respond pretty quickly to different interventions, and they will adapt quickly. Other times, the trajectories of people's lives may change differently, but you can learn quickly whether or not interventions are working. And then you can continue to invest and adapt as that happens. But I think the biggest thing is you'll never receive any of those benefits or recognize any of the changes if you don't start making the investment up front to begin with.
Thank you.
Thank you.
That concludes this year's civil justice hearings. Thank you all for your attendance. Thank you to those online watching and who might watch later. Thank you to the PJs, Chief Administrative Judge Zayas, and President Sweet, who had to leave a little bit early. Thank you all. See you next year.